hit the like button. They're already started. I paused it. It jumped on and scared the mess out of me, so I'm just gonna go ahead and get started.
Representation that I made to the court about the number being on the wire. Within the discovery that was served in 2022, the phone number that we've gotten the records for and the last name of Mr. Boyer is provided within the Sumlin Dorsey conspiracy. And I said wiretap. There are 2 wiretaps that were gotten. This name and this number appears in both, and the name for the number appears in the Sumlin wiretap.
All right, and you produced that to the defense as a part of the Sumlin Dorsey conspiracy package of discovery in 2022. Is that what you're saying?
Yes. You distilled that.
Okay.
And then I said it.
And do you have anything more specific than that to point out to show, like, exactly when that discovery got served?
I do.
Okay.
The 2nd, 2022.
All right.
And the folder specifically that the number and the name appear in the discovery served August 2022, it's folder 1, counts in indictment by act, at 181 through 182, Sumlin, Dorsey. Count 55, 181 through 182, discovery 2, Dorsey conspiracy. And it is the 1, 2, 6 call down, which has on it, and I will submit this as states 1 for the purposes of today.
Okay.
It has the phone number 470-957-2893 Dorsey and Boyer.
All right. Okay, that appears to clear up that issue. So y'all can double check and make sure it's, says what she said it said. I don't know. Let's ask.
She dug herself out that hole.
Can I pass it around? I'll use the floor first.
Sure.
We just screenshot the trunk.
Okay, if y'all got a screenshot of it, maybe send that email around to everybody so they can
Blue,
see.
you funny.
But
Y'all, she dug herself out the hole.
Also, we sent it a second time when we organized the discovery for the defendant. So it's in 2 different sets of discovery. The first one is from August 2022.
okay. I mean, I'm happy to pass that around at the time because she's got it highlighted. You can all take a look at it, but she's going to email, or she or Mr. Atkins are going to email that as well. And then it sounds like it got reserved later in 2022. Thank you, Miss Love, for digging through to figure that out.
Good boy, she lucky she dug herself out of that one.
All right. And then, do you have hands on the affidavit and search warrant yet?
I labeled it Stamp 2.
Okay.
They dodged the bullet with that one.
I mean, I guess the The court reporter is asking about the labeling. So yesterday we had a states 1 and 2, and we sort of had a motion, I guess, with regard to, I guess that was.
We labeled it differently. We labeled it States 1 Melnick Proffer.
Okay.
We labeled today's States Exhibit 1 as States Exhibit 1 August 7th, 2024, if that's today's date.
Okay, so it's weird, I guess, because I'm sure there are 100 million, I exaggerate, but a number of states exhibits that have already been in for the jury trial. We're sort of paused on the jury trial and kind of we're doing motions of limine for the most part, really, sort of, but this isn't that either. This is, I don't know what to call this. Just don't know what to call this. Let's just say it, states 1 and 2 to the Boyer discovery matter.
Okay.
How about that?
Yes.
Okay.
So come to find out, they didn't violate Brady with the Boyer cell details is what I'm taking. They were able to produce that it was in discovery already.
I've got some paper clips.
I think we know where it's secretly kept.
That might be why she quote unquote chief deputy, but she skated through that one. I thought it was over for her ass on that one.
Gotta give it back to me. Yeah, come on up to the.
I'm not sure if anything's been cured or.
Well, I don't know.
So.
Oh, maybe I spoke too quick.
Let me first start off by saying that the discovery in this case, including, I call them dumps, or whatever okay, 1 and 2 came together. And all the different additions, 3, 4, all the way up to, I think, there was 13 or 12. They're divided by counts.
Okay.
Okay, so count 55, I believe.
Is the conspiracy that is connected to the Drinks murder, right?
No, it's not. No, that's one thing. It's a conspiracy. It's count 55 in this indictment, which involves
the murder of Harold Clements.
Well, he's not dead.
Right?
It involves, well, that's not in this indictment. It involves.
What is in this indictment? It's not a count against anybody. The count 55 is not a count against any of the 6 co-defendants on trial currently, yes.
Correct. So it involves something completely and wholly unrelated from the Drinks murder.
True.
Okay, I want to play for you. So I can show Your Honor the screen, but basically, if you click on that jail call, which I guess is Mr. Dorsey talking, it comes up on your screen. It says 0428-2022. I guess that's the date, 4/28/2022. And it says 2218, and then it says a phone number, 470-957-2893. And it says Dorsey and Boyer. Okay, it doesn't give a first name. It just says Dorsey and Boyer.
Okay.
There's no context for us to know who Boyer is, and this is the call that the state is saying puts us on notice that Mr. Boyer is somehow suspected and involved in the Drinks.
Okay.
This is the call, and I just want to play it.
Okay.
Your Honor, Mr. Sharp, Your Honor, if I may just make one point.
Man, goddamn.
We did not represent and are not representing that. The content of that call puts them on notice. What we're saying is that the wiretap, the content of the calls in the wiretap are the basis for our search at getting the records. That's and the connection to the Drinks murder, but it is this
service of discovery that says, hey, that phone number from the wiretap is connected to the name Boyer. Is that what you're saying?
That's what we.
Okay.
It says Boyer, and it just says Boyer, and
Okay.
and if you play this, I would like to be able to play
Sure.
this.
Recall from
Sorry, not what it said. Sounded out.
an incarcerated individual.
That's Mr. Dorsey.
This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Oh, got it. Oh, the fuck going on? It's full blaze. I'm in traffic, so I gotta hear that. Alright, I guess.
That's it.
That's the call?
So someone says, I'm in traffic, I'll hit you back,
All right.
and
Okay, no, and Ms. Love's clarification is, it's not that call that gives y'all that notification. It's the wiretap that gives you the notification, because the wiretap has all these communications back and forth between this phone number, 404-957-2893, and Mr. Garlington's phone number.
Yeah, I'm
And
covering
then
almost
it's
everything at this point.
This bit of discovery that Ms. Love just told us about that says, and that phone number belongs to somebody last name Boyer.
Oh, that's bullshit,
Okay,
though.
but they say they're not using it in the Drinks murder evidence anyway. So that actually, I think, takes care of Mr. Williams' motion in limine filed very recently, within the last hour or so, I think, saying keep that out. Is that right? And I have to confess, I have not asked you that particular motion, looked at it myself yet. I'm just basing it on Ms. Persfield's review of it. Is y'all are saying we want that kept out, and the state's already maintaining they will not introduce it. And so, granted, but also unnecessarily so.
Thank you. Well, I added not only case in chief, but in rebuttal for that, Mr. Boyer. And then there's a second part to it. We received on Monday, for the first time, Agent Bernie's expert report as to a April 26,
Y'all hit the like button.
2015 shooting of Mr. Carter's tour bus.
Okay.
It's been referred before this honorable court as the Lil Wayne bus shooting.
Okay.
And the state has already put up, they said they didn't need to qualify Agent Racy. He's with ATF now. He's former detective in Cobb County. Racy. So I'm going to tell you RACCI, but I may have misspelled that. They already put up painfully. It took days. Tracking phones. They have 3 to 4 different exhibits to your honorable court's right of your bench. They're against the wall, or they should be. I believe that's what they are. Anyway, the point I'm trying to make is now, for the first time, we're getting another expert.
Okay.
Never gave us this information before. And yes, I've had the records. I'm not complaining about that. But, you know, we look at everything and we test everything with our own
Right.
independent experts.
Okay.
And I want that excluded too. That was in the motion as well.
All right. So with regard to, that's two entirely separate. The issue, I realize, is way late discovery is what is being alleged. But we're talking about two different sort of.
Yo, those are nice. Hold on one second.
Oh, shit.
Candace, what's up? I think my daughter's going pro at basketball.
I'll take
Wait,
those.
you're at Dick's?
Boyer plotting of the wherever the cell phone location is. The state has represented that they do not intend to use this.
What's up, AZ?
I'm granting the motion limine with regard to particularly is at least this case in chief, but with regard to if it potentially needs to be used in a rebuttal, at this point, y'all are on notice. Yes, it should have been produced before now. but we're also, I would say, pretty far away from hearing any evidence about the Drinks murder anyway. I am not going to make a blanket ruling at this point that it can't come in and rebuttal either, because y'all got time. I don't know if it might need to be used or not, I don't know, but I'm gonna leave that for another day if and when it does come up. Now, with regard to this second sort of chunk of information that's just been produced, Agent Bernie's analysis of what does that have to do with cell phones too, or just the incident?
He's a cell phone expert, so that's what it deals with.
Okay, okay, so what do you say as to that, Ms. Love? Because if y'all already presented your evidence, or what's your plan with regard to Agent Bernie's report and analysis?
Your Honor, would the court permit me to address the first part?
Shit, how you fucking asking to address some shit?
Your records and get it tendered the evidence and then address
Yes.
the second part of the motion? Okay. So the state is tendering for the court's consideration states 2A Boyer records, which is the affidavit for the search warrant, and states 2B Boyer records, which is the search warrant itself.
Really, bosses? What do you do, bosses?
The court is correct. We stated earlier and state again that we are not attempting to use them in our case in chief. As well, Your Honor, I am marking as State's Exhibit 2C Boyer records.
Mm-hmm.
It is a screenshot of a search of the wiretap data for the number of calls that involve 470-957-2893, and the number of calls within the wiretap that involve this number are 501. So I'm tendering this for court's consideration.
Y'all better stop talking on the goddamn phone.
And 1 as well as 2A through C are admitted. Okay, turning now to the
Bernie separate plots regarding the Little Wayne bus shooting, the data, the cell phone records, and their cell site location information was turned over, I believe, in July of 2022, if I am not mistaken. I'm almost certain that we turned it over in the first set of discovery that we served.
Okay.
So the data that the plots are derived from have been in defendant's possession since July of 2022. The plots that were made at the request of our office were requested after testimony and cross-examination, testimony elicited from through direct and cross-examination of our witnesses in the Little Wayne bus shooting.
Okay.
As a result of some of the questions and answers and the direction that we saw that questioning going, we asked for the plotting of the.
And when did you ask for that?
I'll get an exact date.
Nah, what the fuck? You should already had that. God damn it. I can't stand when they argue something don't have all their info. The state does that shit too fucking much. That shit irritating.
Give me a ballpark.
Okay, like come on, you wasting time. You done had all yesterday evening and today.
When did this?
In the last 6 months, that's the narrower ballpark because things were delegated and we did.
Okay, when did these people testify to the Lil Wayne shooting? When was that testimony roughly? January, June? April, okay. So at some point after April,
Yes.
It probably was me saying what the fuck, cause man.
okay, let me ask you this. At the point in time when you think it might be relevant to have a plot of whatever cell phones might have been involved, we've already heard everybody's testimony. Man, we'd like to shore that up with some expert rolling back in here and taking the stand
Appreciate it,
again.
AZ, for the
We're
super
going to get him
chat.
to plot this. Would it have been possible at that point in time to share with the defense, hey, y'all, we're going to have our expert that y'all already know about anyway, go ahead and plot this too?
Yes, that would be.
Okay. Why was that not done?
And there she go looking stupid again.
So, Bernie did not testify about these. He has.
I know.
Okay.
That slow dumb shit again.
Your Honor, if I may, I'd like to give the court first the more precise time that we got those records.
Not when you asked for them, not when you got them, when you asked for them.
That yes. Before I go to that second question with the court's permission.
Okay. Go ahead. How long is it going to take to get that information?
Right.
Can Mr. Christian work on getting that information?
It's already been worked on.
Okay. I mean, will the answer differ based on when you asked for the information as to why at the time you asked for the information, no matter when that was, you did not, even though you could have, say to the defense attorneys, I'm going to be getting this. I don't know if I'm going to use it or not, but I'm going to be getting it.
That is the best practice, and we did not, but we
Best practice, my ass.
A good answer.
Basically.
I mean, the answer could be because, man, there are only 24 hours in the day, and this is chaos, and, you know, we're doing the best we can. That could be your answer. I don't know. It's still not a good answer, but...
Right. Instead of fucking...
Let's just maybe nip this in the bud, because I did ask you also to, at the lunch break, huddle with your team and
here we go.
see if there might potentially be anything else outstanding, whether Brady or not, because none of this sounds like Brady. It's just information that might come in trial that it would be, you know, just kind of like the way we're supposed to try cases is to sort of share each other's evidence to, you know, with the other side so they know what to expect. So were you able to sort out yet? Is there anything else out there in the universe that you think you're going to use?
Judge, I used the lunch break to get that information I gave to you earlier. We're feverishly getting that.
All right.
Oh,
so,
wow.
All right.
Right now, what I have for the court is that.
Oh, wow. That's wild.
Racy testified on between May 13th and May 16th. So I need to clarify that. And the defense challenging him and as I said earlier, the questions and answers and the follow-up cross-examination elicited during that time period, May 13th and May 16th, is what caused us to request them.
Okay, that's fine. Okay, and essentially, you acknowledge, yes, we could have gone ahead and let the defense know we were going to try to get this plotted. You just didn't. And I guess what I need to have happen going forward is that as this trial is going on, first, if there's anything outstanding like that, whether you've got results back or not, or if you're just like, after somebody testifies, you know what, this would be a good thing. Share it in a timely manner, which is like, not necessarily at the time it occurs to you, but at the time you decide to do it, don't wait for the results to get back. Don't wait till you're going to call the person to the stand. At the time you say, we're going to do this, you give that information to the defense, okay? And then when you do get the results back, you can say, we're not going to use it after all. Or, we already use it, here's the result. And that is going to go be the rule, be the requirement moving forward for everything. So if there's anything out there right now that's kind of in progress, tell them about it. And moving forward, as things come up, when you decide I'm gonna be doing something about this, tell them about it, okay?
Yes.
So what amount of time do you need to get with your team and figure out, is there anything in process?
Friday at 5 too late, or you?
Hell yeah, that's too
Friday at
late.
lunch. Well, okay, I don't know what our Friday is gonna look like, but yes, you can share it with them without it being in court. So yes, Friday by lunchtime. And you can just copy Ms. Percifield or whatever it is you tell them.
Okay.
All right? And
The
I
state's so
expect that to be the rule that
unprepared.
gets followed moving forward, okay?
Okay.
All right, any questions about it?
No.
Okay, all
They
right.
make the system
Anything
crazy.
from the defense on that topic and that rule? And I know it is not ideal, but this, it seems that up until recently, this trial was sort of, everything was on a rolling basis.
That's
And
what
I
it's
can't do a whole lot about that, but moving forward, that's what it's gonna be. Yes, ma'am.
So, Your Honor, that's, everything was not on a rolling basis.
Well,
And the rule that you just implemented was already the rule.
okay,
Chief Judge Glanville, at a certain point, because we were receiving late discovery disclosures
all right,
all the time.
okay.
And at a certain point, he said he was fed up. He spoke to the state. He said he was drawing the line
Pop
there.
your shit,
Okay.
lady.
That any late disclosures after that, and he did exactly what you did today. Maybe not those exact words, but he said, is there anything else?
Okay.
So he gave the state this opportunity already, and he told Ms. Love specifically that if any other late disclosure of discovery came after that date, that it would be met with remedies and sanctions. So we're
Okay.
here again, and I'm just asking that before you exercise patience,
Don't exercise patience.
That part.
Okay, that it was already supposed to have been in place and be aware of that. Okay, so
Get on the ass,
I think
good.
that's probably true. I wouldn't be the least bit surprised if Judge Glenville had already at some point said, all right, y'all, we gotta
Judge
sort
Glanville,
all this out.
in fact, has, and did in fact say, hey, turn over everything.
Man.
And I'd only say that as trial goes and as we see the direction that
Okay. I understand. Yeah, I mean, trials are kind of living things. I get that. But if even if it took you 2 weeks to decide, so like by, Memorial Day weekend on May, whatever it was, at the end of May, you were like, yeah, let's get this. It's now August. So you had all of June and all of July. So, I mean, the motion on the floor is to request that the plot by Bernie be excluded from this trial.
Your Honor, we would ask that the court,
Definitely.
since that is the motion on the floor, deny the motion because the data that has been plotted has been in the possession of everyone. That's including cell site location data.
Yeah,
Since
throw that shit out.
July of 2022. The counsel for the defendant is correct that Judge Glanville said turn over everything that you have. And you have a continuing discovery obligation.
Right.
So, moving to exclude a summary of what has already been given,
What the hell is
we
that?
would argue is an extreme remedy given that the information that is contained in that plot that was given to them has been in their possession since July of 2022. And this is something that we requested. I haven't yet even told, I don't yet even have the exact date that we received it back, but we did request it around May 23rd or shortly after that.
All right, and the plotting that Mr. Burney did, is that with regard in the report that's come back? Is that in regard to the Donovan Thomas murder?
No, the plotting that they're referring to has to do with the Little Wayne bus shooting.
Oh, right, y'all told me that, I'm sorry.
That we put up the evidence of.
All right, so have you had Bernie testify yet?
No.
So when I see on your witness list that you've most recently provided to everybody, that Bernie is listed as your expert, or not his, expert with an expert report and phone records for count 2, which is the dominant. Okay, so is he then listed again for where?
Yes, he's not in the. He's also in the last 30 set of witnesses for a different act.
And is that the bus shooting?
The Chamel drinks. No, the bus shooting we've already put up evidence of.
So are you planning to call him to say, and here's the plot of everybody for the bus shooting?
No, what we did was we introduced Detective Racy to do that, but the defense challenged Detective Racy's ability to do that.
Okay.
And so for that reason, we had Agent Bernie to plot them.
Okay, so Gracie you had attempted the plotting through that witness?
Yes, we had introduced, we introduced and attempted to introduce plots of various numbers. There were challenges to
all over the place.
Racy's ability to plot various numbers.
Okay.
There were.
All right, but you at no point after you knew you couldn't get it in through Gracie said, all right, we may be trying to get this in through Bernie.
Did not. No, we never did that. And I want to be clear that it had to do with the line of questions that were put upon Agent Racy.
Okay, so I mean, sure, it only came up that this was a possibility after Gracie testified.
We only decided to do that after that. We were intended to be done with that.
But it's still been 2 months since that time.
Yes.
And so why is an appropriate sanction not at this point saying you cannot use that information through
that part?
Period. You can't use that information. I can't let Bernie testify to that.
Because 2 reasons. The remedy of exclusion, as the court is aware, is one that is extreme, and generally it would be appropriate when there has been some kind of harm and there has been some kind of bad faith. I'm not saying that that's the only time the court makes the decisions. Our argument would be that it should only be employed if there's something prejudice.
Yeah, I understand. So how is it not bad faith? And I don't mean this personally, but how is it not bad faith when you've been ordered by a court, probably orally and in writing, that you need to produce things as they come into being and as you know about them, and then you don't do that?
Bad faith would be holding it back for some kind of advantage, tactical advantage. And if we're saying we don't have to put that up until the last 5 witnesses, and we are at witness 80 in a list of 175, giving them the records or the plots now. Literally, when we have people,
Okay, so that sounds more like an argument that they aren't really prejudiced because they still have plenty of time to handle it, right?
It's actually for both, because what I was saying is,
Judge,
to
all
say
that
it's
shit out.
bad faith would mean that we held it back, or, I mean, that's still not the only definition of bad faith, but we did not, we did not hold it back
She sounds
for
crazy.
any. We did not intentionally keep it from them.
Okay.
It's
So how is it that it came out on Monday or occurred to y'all over the weekend and you produced it on Monday? Is it because because y'all finally got together and said, all right, y'all, what else is there that we ought to be giving them? Why 2 months later?
So,
You drowning, love. You drowning. I love it.
the moment that precipitated this disclosure, I have to rewind and go back over everything that has happened. And I can only say that it may have been that the court, it may have been that as we were looking at 30 witnesses out and looking at Bernie, we realized, oh, Bernie.
Okay, so it basically was just the court saying, it's time to get organized and it's time to share the details about what your intended trial evidence is going to be that finally made y'all get organized enough to realize, oh shoot, there are some things we have not shared yet. Fair?
It is the court's order that got us to do that.
Okay, all right, so that is probably not bad faith. That is it being swamped because there's a lot of evidence.
Oh, no, do it,
But
Judge.
I am exercising patience despite the suggestion that I not do that. And I hear that you probably think enough patience has already been exercised. There is a long time before this witness is going to be called for this purpose.
Oh, hell no.
It is more difficult to prep for evidence as the trial is ongoing than it would have been before. It's more difficult to do it with 2 fewer months' time than it would have been with 2 extra months' time. This needs to be the last of it. I mean, it's sort of like
Oh, hell
when
no.
somebody comes before me on a probation violation and it's the first time I'm seeing them. I don't know what they thought about getting away with anything before that. But once I talk to them, I expect them to abide by it. I expect you to abide by it. So between now and noon on Friday, you better make sure you have got all your ducks in a row and you have shared those ducks and ducklings with the defense.
Yes.
Okay.
She done got through it again.
I'm about ready to move on from this, but yes, ma'am.
Okay, Your Honor, I'll be brief.
Speak into your mic.
I'll try to be brief.
All right.
Your Honor, in all candor to the court, I believe that the state is arguing as if it's a first argument to you because they know you haven't been here for 19 months. These arguments, I've heard them so many times, it's countless.
I understand.
Right. And for the state to argue it's not bad faith, I'll give you an example.
Oh, that's hard
things that we've been
playing
through
it.
before we had the opportunity for you to be presiding.
Can I ask you a question before you do that?
Sure.
Is this something that is...
Oh, damn commercials.
Can you repeatedly, systematically make the same mistake as an experienced litigator?
Pop your
and
shit,
say
lady.
It's not bad faith.
Okay.
Your Honor, I'm just asking that the rules be enforced. Because if they're not really rules. They're just aspirational.
All right, I understand. And we are instructed ad nauseum by our appellate courts, they probably won't like my use of that term, that exclusion of evidence is an extreme sanction, and that prior to a trial court instituting that as a sanction, the
Love, nervous as hell.
solutions that need to be thought about include a continuance, which is not going to happen here because we've been on a continuance for a while here anyway. A continuance here, it's, no, they cannot bring it up next week. It needs to be way far down the road, which they are representing.
Man, stop shaking your goddamn head. What am I
anyway,
down?
so it
I ain't got
will
my
give y'all
tissue in here
time
today.
to look into whatever it is. And I understand what you're saying, and I hear you. And the answer to how many times can it happen? Maybe 0 more times. Okay.
Not
not trying to keep us from moving on, but related to this, my
Yes.
understanding, I'm sitting way back here. My understanding is the state admitted some court exhibits to include the affidavit and the search warrant
Right.
for Mr. Boyer's
Yeah.
phone records. Is that correct?
Yes.
Could the state? We still don't have those.
Okay.
So could the state send those to us?
Can y'all share those by email, or should I have copies made of these?
And additionally, my colleagues are correct. We would also like all reports. The statement that the state has made is there's been a continued investigation into this case, into Mr. Boyer, and we would like all associated reports, investigative reports, summaries, supplements
Everything.
involving the continued investigation since our client's arrest.
Reasonable. Ms. Lab, you understand?
Yes, yes.
Everything with regard to the police investigation of Mr. Boyer and any kind of involvement of his in any of the crimes indicted in this case. And let's ask for it before the end of the day and make sure you have it before, I mean, it should be by like sometime mid next week. And if it is going to be any longer than that, you let us all know why.
That's too damn long. That's too long. They should already have it. What the hell they still investigating for? In the middle of a trial. A RICO at that.
Affidavit and search warrant and whatever else it was. Is that something y'all can do electronically, or do I need to get copies made?
I'm actually checking to see if
They can't do shit.
brought over
Fucking the lappy ass pocket.
Okay.
of both the warrant and the affidavit.
All right, let Mr. Atkins look for that, okay? Huh?
Yes, it is. We can provide physical copies.
Perfect.
Do not have a copy of the screenshot of the number of times the number shows up.
Okay. All right, but you put that on the record, and y'all, and y'all are welcome to walk up at the next break and look at it, but it essentially is just this one line that shows
Still gonna eat her ass up with his next motion.
500-something times, okay? And she's gonna share hard copies.
They like some kids that had a project for school and ain't do their motherfucking homework. Hell yeah.
Okay.
The lappy ass prosecutors. The fuck?
Yes.
During the trial, you're going to be met by Mr. Williams with an objection to Agent
I'm sorry,
Bernie's.
say that again.
I'm going to raise an objection to Agent Bernie
Okay,
about the going backwards, what's testified to, and I heard
okay,
what the prosecutor said about, oh, this came up because of cross-examination. My memory is strong. My memory is that all of our objections to Agent Racy testifying about cell site location data was overruled. The state put in all this evidence for a long time about where every phone was. So you'll be getting a cumulative.
okay. If that is in fact the case, yes, please point me to where that is. And I mean, if it all came
They on her ass
through
today.
Agent Gracie anyway, then I may revisit my ruling. But let's not take that up now. Y'all can file something and point to that part of the testimony. Okay. All right. All right, so back to the plotting detail that we are engaged in with regard to Mr. Zachary's April 2017 statement. And let me, before we get back down into that, I was going to go back and listen to a portion of the video that had to do with item number 13. Let me find my list. Gotta find my list. but y'all have your list, so. No, that's fine. I'll just need to have somebody from my staff walk into my chambers and find the 3-page list.
They had it on Twitter that he was in traffic court.
And bring it up here. I've got an electronic copy of it anyway. Here it is. Anyway, it had to do with.
Make sure y'all subscribe to the channel, hit the like button. On the road to 20K. We need 165 more subscribers.
18 through 22. I was gonna go back and look because I was trying to figure out who they was. So, having listened back a ways and listened forward a ways, it's pretty clear to me that Mr. Zachary, at this point, when they say, when the investigator asks who they say killed him, and he responds, shoot, they say Woody and them. I don't know that for a fact. That the they there is who do the people that you were with at the condo later that evening say. So, I am gonna actually go ahead and I think I had tentatively ruled that out before, but I'm gonna permit that after all. Because that's, to me, pretty clear that he's saying that very evening, this is what the group was saying. All right?
Judge, you look iffy now, because you doing too much.
All right, so I think we are were we on item number 53 at this point? Anybody?
We had, gone on that, page 157, the last address line.
Okay, right. Great. So then item 53 is on 158. Okay. So 158 lines 12 through 21. Okay. Okay. So then we're at 159, 6 through all of 160.
What the hell is that?
And I guess the objection is this is incidents entirely unrelated to anything that is a part of this indictment and that it's hearsay? Okay. Now what's the state's response?
Based on prior representation, I don't have an objection.
Okay. So that is out by agreement.
So just, I'm sorry.
Go ahead.
Starting at line 6 on page 159.
Right.
Yes.
Yeah. Okay, so the next is 170, lines 10 through 17. Oh,
I plead my objection, but you can conspiracy, but I would concede, I'm not withdrawing my objection, but I would concede that this would fall under that same
All right.
reasoning that you've already admitted the other ones.
Okay. Thank you. Essentially, we don't need to re-argue it. Got you. Thank you. All right. So, my ruling as to this will be the same for the same reasons. And are the items listed in 56 essentially the same again? Same
I
argument?
believe so. I'm just reviewing it to make
Okay.
sure there's nothing.
All right.
It's all over.
All right, looks like the first chunk, 174 through 177, is all this kind of same thing we've considered argument about. Do you agree with that?
I do.
All
I
right,
also agree that the second chunk
okay,
as well.
all right,
I'm looking at the third right now.
all right. Same for that last one too. Do you agree that the last one's the same as well?
I'm almost done.
Okay, I'm sorry, I don't mean to be rushing you, I just don't wanna be thinking that you're done and you're waiting on me or anything.
I would agree that it appears that that is all based on what Mr. Garlington said to Mr. Zachary.
All right. Okay, and so for the reasons stated before, I am gonna admit those three portions of the transcript over objection is obviously, assuming they end up needing to come in and foundation is otherwise laid.
I do have a motion, and I believe that, or not a motion, but an issue that is in this section, and it's interspersed throughout both sections. And when Mr. Zachary
Okay,
advised, presumably.
can you talk into your mic?
Yes, so my concern, I understand that I disagree with it, but I understand that Mr. Zachary has claimed that my client made certain confessions to him. I would argue that we need to figure out, on my client's behalf, what we're doing with the confessions that were made allegedly by Mr. Kendricks to Mr. Zachary, because that is as I understand the law, I don't see that. Seems like it's spilling the beans. It does not seem like it, and I understand that statements made by Mr. Kendricks, if the jury believes that he made them, can be used against Mr. Kendricks. They should not be considered against my client, Mr. Stillwell. And I would assume that all the other attorneys who are representing neither Mr. Stillwell nor Mr. Kendricks would have an argument that those statements should not be considered against their clients if they're being admitted as statements by a party opponent.
And for what it's worth, Judge, if I can just join on behalf of Mr. Williams, I was getting ready to kind of jump in and say the same thing. That I understand the court's pronouncement previously. I understand the state's position as to what they contend those statements are. But in so much as we're charged in this indictment, and we believe that those statements may be admissible against those particular individuals who made them. We do not believe that they're admissible against us. We believe that they do fall under the category of spilling the beans, and that they should not be. They may be admissible against that person, but not against us, and we'd object to those statements being admitted.
All right.
Your Honor, if it were that it was, we were only saying statements of a party opponent, in that world, I would have one argument. In this case, we have that they are co-conspirator statements, and all of the defendants currently on trial and the people who are making the statements and the persons to whom they are making the statements are alleged co-conspirators,
Right.
which makes them admissible for each of the defendants.
It makes them admissible as long as it is still a statement made in furtherance of the conspiracy. And so y'all are gonna need to talk detail to me about when in time and to whom and under what circumstances co-conspirator statements were made, because I can't make a blanket ruling that everybody on trial or everybody indicted, everything they ever said to each other falls under that exception. So let's maybe sit that to the side, but come back to it to the extent I haven't already made a ruling, because it just is going to depend. Okay, so I mean, I don't know, let's just let me add that to my list of things we still need to do. But y'all are going to have to bring to me the detail about what and when and to whom and all of that.
So, Your Honor, that is for sure. That's what we expected. What we were undertaking here is not even an assertion.
Right.
Okay.
Yeah, so we'll do that another time. One other thing I noticed in what we just were looking at is there was mention made of a McDonald's video, and I think just maybe in passing, Mr. Sharp, you mentioned that nobody's ever produced that video, and I just want to make sure, does the state have possession of any video from McDonald's, and if not, did y'all or somebody from law enforcement go see if any such thing exists?
Your Honor, yes, evidence through testimony has already come in that at least one investigator, along with her partner, attempted to obtain McDonald's video. She was not able to. The lead detective was not able to, did not. We don't have any McDonald's video, and we don't have evidence that anyone has McDonald's video. And as the court already knows, in
McDonald's video
portions that are reflected in the transcript, it says
GTA what
someone's
do?
trying to get McDonald's.
Murder Man, what's up?
Okay.
Sheena, what's up?
Then item 57 on page
Hit the
1.
like button. Make sure y'all subscribe to the channel. Trying to get to 20K by the end of the month. We might can do it today. If y'all tell y'all friends to subscribe to the channel.
You're going with Withdraw it? Okay. All right. Item 58. Well, I'm sure these had started out as kind of notes to yourself.
Yes,
So
I
don't
did
worry
not
about
do
it,
the
but-
best job of laying out exactly what my objection is, but it starts out with speculation, it seems to me, about, on behalf of Mr. Zachary, about why people are not hanging out with Woody, who's Mr. Copeland, anymore. And then they get into a discussion about a word that I don't even use, quote unquote, snitching. And I just
To respond to Mr. Sharp's relevance objection, what the court has, just to give some background, in 186, on page 186, starting at line 1, Dennis flat out asks, after Woody came down here and talked to the police, it was almost like everybody was distant from him. And Mr. Zachary says, yeah, we have, and I anticipate we will here, we'll see through Mr. Copeland. But there are multiple statements that Mr. Copeland gives regarding his distancing from other members of YSL after he went down and talked to the police. That's one thing. Later on, as in line 8, so in line 6, Detective Dennis says that, did they distance himself from them because they thought he was snitching? And Mr. Zachary clarifies, it's not about that, but he snitched on the person who shot at him.
I mean, it essentially ends up being a conversation like, no, it's that he got the police involved at all. These kind of things ought to be handled amongst the people that have issues with each other.
Yes, and so for 2 reasons, it sort of tells how they operate, and also to the extent if Mr. Copeland says, no, I didn't say that.
Yeah.
It would serve to impeach that and to further show that this is how we operate.
Okay. I mean, I think it's certainly relevant to showing how they operate. Now, if there is something more in particular about, a certain phrase or a certain question that you think could be excised, let me know that. But I think the overall concept is a relevant one in this trial.
Judge, let me interpose this if I can.
Okay.
I hear what the court's saying. I hear what the prosecutor's saying as well. But for it to be a relevant issue in this trial, it's got to be relevant to, for example, someone's testimony. And the discourse that we're looking at here isn't them saying that, for example, Mr. Copeland isn't saying something or is saying something, or people are getting upset at him for snitching. They're having this and I'm going to use Mr. Shaw's word, kind of this philosophical discussion about, whether people should be talking to the police or not.
Right.
And you can have that discussion. They can have that discussion without it and have that opinion, because quite frankly, the detectives are also interjecting their thoughts on why people do what they do. That doesn't make it relevant. they're having this discussion about whether it's appropriate to talk to the police or not. But there's nothing about that discussion in and of itself that really tells us anything germane about the facts of this case. You can say that, for example, the state can say, for example, well, this goes to show how they operate. Well, a person can have an opinion without it going to show that they operated in this particular manner in regards to this case.
All right, I agree, and you can make that argument to the jury. Thank you.
I think it also goes to, it borders on propensity as well. To say that someone has a propensity to act in a certain way that might be consistent with whatever their theory is for this case. So I just think.
Okay, well, it's not specific other acts, and if it were, it's intrinsic to this set of charges anyway. So overruled. Thank you.
Should have been overruling that damn love ass earlier.
All right, moving to 191, item number 59.
That judge be tough on some stuff, and then she be walking real light on other things I've been noticing. Cause Love wasted all that time this morning, and she was real light. Now she's like arguing with the jury.
All right.
Argue with the jury about it, but not arguing.
Then 192 is our next one. All right, and that's lines 16 through 21, Miss Love.
We up to 20. Yes, we don't have any objections
All
to
right,
that.
16 through 21 of 192 out by agreement.
I would draw 193.
Okay. All right, so that's, you'll withdraw as to your item number 61?
Yes.
Okay.
I would draw 62 as well.
Okay.
And Your Honor, for 63, if I don't want to withdraw it, because if you saw the way, if you agreed with my arguments about Kamikion's statements, I think it would be inappropriate for Investigator Dennis to repeat Kamikion's statements. But I would for the purposes of this exercise, I would concede he is repeating alleged facts that Mr. Zachary is saying Demekian told him that fall under your previous ruling.
Okay. All right. All right, so that's based on the same rulings as before. Okay, now we're at item 64, which is on page 206.
And Your Honor, I know you have no context for this at all. So in discovery, there is I would term it as completely innocuous social media post of my client that may have been posted on January 10th. I believe it was taken at New Year's.
Okay.
January in 2014 turned to 2015 with my client just kind of standing there, and it said something to the effect of looking at the city with a lot on my mind,
Right.
or something like that.
Okay.
Somehow that's being posited as some sort of confession, or
Right.
which I don't really understand. It has not been admitted into evidence yet. I'm going to argue that it should not be admitted into evidence because it has no relevance. So there's reference to this
Right.
picture, and
Okay.
I
Do
guess
we?
pending.
Sorry. Go ahead.
No, you're trying.
I understand. So, do we even have any idea what time it got posted in relation to Mr. Thomas's murder?
Your Honor, the time, I believe, is on the post, so it's after, make sure. The time is on the post. And I
Okay.
know the time. And my memory that I'm gonna confirm is that it's around 10 something in the evening, but I'm gonna confirm that. I mean,
What time was the
7, it's a little after 7.
7-something p.m.?
Yes, it's a little.
Okay. All right.
So it was posted by Mr. Stillwell on January 10th at 9:58 p.m. is the time and date of the post, on the post. So,
January 10th at 9:58 p.m.
yes, after yes.
Yeah, that's gonna be permitted.
In that case, Your Honor, there's nothing there's nothing about this discussion of it
Right.
that is by itself objectionable. It's just, I object to the evidence itself. So
Okay, yeah. And I mean, I don't know why on earth this part of this would end up being something that gets fitted as hit prior inconsistent statement. Who knows? But to the extent it does, it can come in because I think that the evidence itself would be admissible considering it's the post and the commentary is 2 hours after the murder. Okay. All right, takes us to 2:15.
We'll withdraw that objection.
All right. All right, now we're on to page 222.
On this one, it's a very simple objection. They're talking about the phone records and alleged communications between Mr. Winfrey and Mr. Williams on the night of the shooting of the Lil Wayne tour bus.
Okay.
Mr. Steele and Mr. Adams Investigator Underwood interjects and says, Mr. Zachary is saying that Mr. Williams didn't answer the phone, there was no communications.
Right.
Investigator Underwood interjects and says, that ain't what them phone records say.
And that's not true. Right?
That's correct.
Okay. Any issue with taking that out, Miss Love? Just lines 24 and 25 of page 222.
I don't mind.
All right. Thank you. Okay.
We're really 1 through 12.
You're gonna make an argument that this should not be redacted?
So yeah, I'm sorry.
All right.
I don't.
Okay, so item 67 as listed is out by agreement.
Y'all make sure y'all hit the like button and subscribe to the channel, please. Litigation be so boring. But they got to do it.
And the next one,
Yeah,
I don't have any objection.
all right. Thank you.
And so part of the reason that my initial response or reaction to it was to keep it in his only that he was Mr. Zachary throughout this
particular part. So that's essentially, I mean, I don't know if the overlapping conversation actually, y'all can understand it adds anything, but at least what's on the transcript 20 through 25 is not additive to anything. So can we just strike the entirety of this page by agreement?
Yes.
Okay.
Yes, John.
All right. All right, the next one, 225, 1 through 6, appears to be admitted speculation. Unless I'm missing something.
One through I agree and don't object, and I was actually looking further down.
Okay.
One through 6.
Okay. Okay. Now turn into 228. All right, Ms. Love.
So, the judge, this portion of it, the reason I wanted this in is that
I know why you wanted it. Why is it admissible?
so,
Oh shit! About to knock the whole table down.
all right, so I don't have any objections to 7 through 17. But Mr. Zachary's assertion that they, and the way I read it and understood and listened to it, YSL knew that Donovan Thomas's gang had shot up Thug's car. I believe that that statement reflects a general understanding that he shares and that his cohorts share within YSL. And I would argue that that part goes to prove count 1, and it provides not that we need motive for murder, but
The Woody get on Instagram flashing money and junk, and the Nut Gang had done shot up Woody, Thug's car.
no, when he says you're listening to some nuts gang, gift gang, shot up, and
Is that the part that you want? Is that like basically lines 17 through 19?
yes.
But Judge, you don't look at it in a vacuum, right? If we're talking about looking at it from line 11.
Yeah, now I'm just trying to get a handle on what everybody's even arguing. So if she's saying trying to figure out now, like, she's saying, I don't have an issue with some of it. I'm not making a ruling right now. I'm just trying to get a handle on things.
Yeah, I'm just trying to point out that the analysis is the same, whether we're going from 11 to 17 or 11 to 19, it's still the same analysis. That what the speaker, what Mrs. Zachary is doing is he is giving his assumption as to why something is happening, what people are thinking, and it's clear, right? What he's talking about, well, that's what everybody thinks. And it's because, Woody got on Instagram flashing money, and people think that the Nut Gang had done shot up Woody or Thug's car. All of that is assumption and speculation on his part. It's just not, it should not be admissible.
Okay, I don't think it's an assumption on his part that Woody got on Instagram flashing money, is it?
Not that part.
That's a fact.
That's a fact.
Okay.
Woody got on Instagram.
And it's also, I think, a fact, but I don't know, y'all can tell me differently, that people from IF shot at cars in the parking lot that night.
They believe that youth gang shot.
Right. Someone's belief, though, is not evidence. Okay. There's certainly been no evidence. That's an issue for a jury to make.
The fact that this group of people thought that this other group of people that they are beefing with have done some shootings against people in their group is relevant, whether it is true or not. Their thought about it is relevant to the issues on trial right now. So to me, the only way this 17 through 19 comes in is if Mr. Zachary gets on the stand and says, no, I had no idea that Woody got on Instagram flashing money, and or no, nobody that I ever hung with ever thought that IF did anything about the shooting in the parking lot that broke a windshield on Thug's car.
Right, it would have to be an inconsistent statement. He would have to. All
right, so 17 through 19, that little portion, if he gets on the stand and says one of those things, then whichever part of that is inconsistent, you can say, didn't you on whatever day basically say this? But that doesn't mean 11 through whatever the next page is. That means that Woody got on Instagram flashing money, or Nut Gang done shot up Thug's car, okay?
Yes.
The rest of it does seem like, well, if other people think such and such, here might be the reason they think it.
They don't. I don't see that they have an objection beyond 19.
It's page. I believe it's supposed to say 2. Well,
I thought it went all the way to 229, line 19.
yes, that is correct.
The one that I have.
No, I know, it just says 2219, but he means 22919.
So I have a different response with that understanding as to 228, 20 through 24. And
okay. All right, so 228, 11 through 15, or the beginning of 16, is out by agreement. 17 through 19, only in under the very limited circumstances I just relayed. So now 20 through 23.
So throughout this trial, again, there have been battling contentions regarding the relationship between Quantez Lamar, who is originally Quan, and defendant Williams. So when A.J. Springle asked whether Rich Homie Quan, and actually this part is, there's some evidence that
right now, 20 through 24.
So, when he said, when Mr. Zachary says,
Yeah.
and then talks about the fact that, Thug and Nut were hanging together.
Right.
While we and Shell were shooting each other.
Right.
It's just his observation.
Okay. Yeah.
I don't
That part,
have a problem with
you don't have a problem with that part. All right, so that part is in. There's no objection to that part. Okay, so now we turn to 229, 1 through 19. And what's your objection, Mr. Sharp, to 1 through 19?
Mr. Zachary seems to be talking about not just generalize how this isn't a situation where previously it was argued kind of how the group felt, but he's talking about very specific instances, it seems, where they were asking about Jeffrey calling, Mr. Williams calling, speaking with Mr. Thomas, and then he's saying, no, Woody called Shell Keldo, and those are very specific instances.
Right.
I don't know that I don't know what his source of knowledge of that is.
Okay. All right, so hang on. 1 through the beginning of 5. Miss Love?
So there have been, assertions regarding this call and, there have been assertions.
Okay, so is any of the assertions that there's evidence to back up the assertion suggested in Investigator Underwood's question on about what Thug did? I know that there were suggestions that Nut might have tried to quash something. Is it just pure speculation that if he did in fact do that Thug said F you?
I don't object to that kind of.
Okay. All right, so 1 through at least 4, the answer no is out by agreement. All right, what about the rest of it? Beginning, Woody called Shell Kel, Nut's hanging with Thug, and Nut really doesn't get involved with this.
You know, my major opposition to this is well, I'm going to defer to Mr. Adams on this if he has a problem with it. I don't really have that much of a problem with it.
All right.
Neither do I.
Okay. Then the objection to 129 line 4, beginning with Woody called down through 19 is withdrawn. Thank you. All right.
And, Your Honor,
Yes.
I would endeavor to establish a foundation before I make any kind of proper or ask flat out that kind of question.
Okay. I mean, sounds good. Okay. moving to item 71, page 235. Okay,
This is where I think I have a problem, and I know that in some ways this answer is helpful to Mr. Williams. I don't, and Mr. Zachary, I don't. He's saying he doesn't know.
yeah.
Who killed Donovan Thomas when it comes back to it. He's saying what he heard from Demekion Garlington, but then in a conversational, the way we all have conversations, he puts out a hypothetical. If you're talking about Jeffrey Williams, if your circle kills somebody, they're going to think you or that all of them together. So
Yeah.
and the hypothetical, if your circle kills somebody, is, I don't think it's appropriate to have that hypothetical thrown in there because it assumes my client's guilt.
Ms. Love?
Your Honor, this is two things. We're talking about a circle, we'd argue he's describing a group. He's acknowledging the existence of an association, and he's saying these words to the police after he is, according to him, told that two of his group have caught someone down bad. And he's essentially saying, if your clique, if my gang, calling it a circle, but they also at various points throughout the earlier interview, they referred to it as a gang in 2015. If my gang kills somebody, they're gonna think that all of them be together. So he's acknowledging the association, and in it he's talking about, he's speaking on something that defendants Kendrick and Stillwell, according to him, have relayed to him. And that's the way that he tells the police that Mr. Kendrick and Mr. Stillwell told him, we caught that in down bad. And he talks about what we caught him down bad means in the 2015. And even in this one, he talks about, I think Mr. Bailey asks, what does caught him down bad mean? He's asked during this interview, and he clarifies, we shot him.
Mm-hmm.
He says that. So I would argue that this is relevant, and it goes to prove count one at the very least. And that's it.
All right, so because that's just his circle, if Mr. Zachary gets on the stand and says none of these people hung with each other, you can cross him on, well, you called these people his circle before. Okay? The rest of it, out.
through 24?
I think so.
Yes.
Okay. I didn't have any objection to that. That was the one that
Okay,
that's like 7.
all right. That is,
That's a good point. North side. Y'all make sure y'all hit the like button and subscribe to
72
the channel.
outright agreement. All right, moving to 245 through the top of 240, the very top of 247. Bless you.
All these doggone statements is crazy.
Miss Love.
So
Seems inappropriate to come in.
Right.
What happened?
Yes, right. There's obviously gonna be discussion about what he's given and all of that, but right now, I agree, I don't have any objection
All right.
to that.
She said today.
But
There we go.
and I'm just not objecting to all of what's on actually lines 1 through 18, because when he's asked,
Wait a minute. 1 through 18 of which page?
45, because that whole conversation up until that point is about who's going to jail, what time you should get,
Okay.
and all of that. But at line 19, when he's asked, do you realize how much you contributed to what's going on?
Okay.
He's acknowledging some things.
Okay.
I mean, he's pled guilty to these charges. I mean, I don't really foresee him.
Okay, well, this is only if he says, no involvement. Then, if she presents the guilty plea and he says, I only pled guilty because I just wanted to get out of jail and I had already served enough time, then she can say, well, I mean, it's also because you actually did them, huh? So, under that circumstance, 19 through, 245, line 19 through 246, line 1 would be okay.
Oh, shit.
And as to lines 2 through 14, depending on how you testify. So, Mr. Zachary at first pushes back on getting guns for them, but he was also convicted of straw purchasing.
Yeah, and he's busy saying, yeah, I did it. I was young and stupid, but I did it. So, okay.
So actually it goes down to 18.
All right. So that's 3 through 18, potentially. Okay.
I don't have any objection to 19.
Okay, so 19 through 25 out by agreement. So would that go all the way to line, okay, so through 247, line 2, okay. Thank you.
And you're under 74, next one is, would fall under your previous rulings about Demikian's statements
Okay.
to Mr. Zachary.
Okay, so on same basis. That part would be in.
I think they're gonna have an issue with Quandarius. He didn't even want to sign his subpoena.
249 line 22 through 252.15.
I think he gonna be more complicated than Woody is.
I don't have any objection to 22 through 25 on 249. And up through 15 on page 2. And actually, the rest of it. Because it's just a little slips that I wanted, and it's just not gonna play well trying to get in that one. Demetrius, your boy,
Yeah, okay. Alright, so he goes all the way through, at least the objection goes all the way through 252 line 15. So let me know about 251 and 252.
Now, 251, again, only assuming that, he makes some assertion that makes the fact that he's sitting right there with his attorney relevant when he's doing a proffer.
Okay. Okay, so.
And
if he gets on the stand and says, man, everything in that statement y'all coerced me into, then you can say, your attorney was right there.
there's no reason, I don't,
Okay.
absent a reason, I don't object, absent.
Alright, so, but otherwise, you were good with. Okay, so what about all of 251? And then on to 252 line 50, which may be.
All of this, rethinking how I was looking at it,
Okay, alright. So that is out by objection with the one caveat that if he says, you can't believe any of this because I was being coerced, then you can say, did you have an attorney with you? Okay.
And also, Judge, I'm not, there's a question that wasn't objected to. I haven't voiced to the court the two areas that I would argue need not come in. Because I think that we should, for clarity, just go through what has been requested by the defense, but I'd like an opportunity.
Okay, so we are now at the end of the defense's requested redactions, exclusions, as to this statement. So if you think that there are things that the state believes should not come in, now would be your time to present those.
So, actually, that part that I was going to say, that part is already, I didn't have any objection to the 252 through line 15. That was actually.
Right. Got it.
Conveyable, aggregate, and hot mix hauling.
Now, as soon as I come back to the damn thing, y'all hit the like button. It's 100 people in here, only 34 likes. Hit the like button. Y'all make sure y'all subscribe to the channel. We on the road to 20K, and we almost there.
Page 205, where Dennis said essentially, now it's him saying, I think, despite what Mr. Kendrick and Mr. Silva have told me, I think this. I don't have I would argue that it is a false assertion, and understanding it is an inconsistent statement with what he has said earlier. One could argue that it's admissible, but just because he's saying, he's asserting that it's speculation.
I don't follow you. Are you saying that 205 lines, I guess, what, 4 through, I don't know, 1 through 23?
No, it was
7, I don't know, 11, okay. Well, 11 starts with by itself, so there has to be some reference to Woody before then. Okay. And maybe the indiscernible part on 8 is where he mentions Woody. You might want to go look back and look at that or listen to that, but okay, so he's saying, Zachary is saying, I think this was Woody. And if the others were participating, then it's because, you know, he got good talk with them. So when would you be planning to use that?
I wasn't. I think I was the court.
You want it,
Yeah,
you want it out.
yes, that's what I was saying.
Okay, and why?
It wasn't addressed, and I was saying that it should come out.
Okay, why?
Because he is asserting that I'm just speculating. I don't believe he's,
Where is he asserting that I'm just speculating it?
when he says,
Who do you believe? Okay, so this is like, here's what I think. So I mean, yeah, it's relevant if he's saying these 2 people told me that they had involvement.
that's where I'm.
Yeah, okay, so I'm thinking this is not redactable unless, yes, okay. Any other parts?
No, that's,
Okay. So we've gone through the April 13th, 2017 transcript, that interview with Mr. Zachary. Let's take a bathroom break. Be back in about 12 minutes at 3:30.
yes, ma'am.
Okay.
Locked up, they won't let me out. Oh. Alright, y'all, so I don't know about y'all, but I know I've been restless over here, okay? I've been in a washing clothes. I've been in I've been just doing housework. It hadn't started raining again. But y'all, I'm gonna be honest with y'all, probably nothing else gonna go on today. And this pretty much probably gonna be what we're gonna be dealing with for the rest of today. Tomorrow, what's tomorrow? Thursday? Friday might be a little interesting because that's the deadline for a lot of things. I don't know why the judge is not like going through these motions and like getting on, you know, granted or denied. It's still, to my last count, let me see. My last count, I think there's 2 outstanding motions for mistrial still. Like, I don't know what she waiting on. I just think it, for a judge like her who always say, how time management is so important, and how, let's not waste our time. She is wasting time because you need to make a ruling on those, because if you're going to rule in favor of the defense, then all of this is for nothing, right? All of this is for nothing at all. But nevertheless, that's just my opinion. That's all I'm saying. That's just my opinion. All right. Earlier, y'all know Love found her way out of that little situation with Brady. But earlier, when we was watching Lead Attorney, it was mentioned that Hilton was in Boston. And shout out to Thugger Daily that keeps up with everything YSL trial, okay? So she is currently at the NBPA. And it said, for those asking why 88 Hilton hasn't been in court this week, she's in Boston with DA Fannie Willis attending a conference for the National Black Prosecutors Association. Hilton is the president of the NBPA. Fannie Willis was awarded the President's Award of Excellence. She looked different in her photo. Shout out to her, though. I like that photo. That's a nice photo. Okay, Fannie. So that's why she wasn't there. And y'all know earlier it did seem like Love was drowning. Yeah, let me refresh this. But yeah, I think it's only 2. Whitaker point blank asked Miss Love, how is this not bad faith? Miss Love says it's only bad faith if they're trying to get an advantage. Okay, so what's this motion? Brian still has filed a motion to exclude all the expert reports related to cell phone evidence that was withheld from them by the state until 2 days ago, violating discovery rules. But I don't recall, I don't recall. I think she did she grant that? I think that's the one she granted, or did she deny it? I kind of think she granted it. Because she granted the report not to be used. Like, or was it the cell data? She granted something not to be used that still requested. But on the other flip side of it, she allowed the plotting. Yes, the plot. The cell mapping plot to come in. Because she said, well, moving forward, just make sure you provide everything to the court. And remember the lady, I don't know if she's part of Harvey's team or whatnot. She was like, nah, they getting too many chances. Even Judge Glanville gave him a chance. Yeah. We're gonna have to recap. Oh, here we go. State has said they decided they will not be using the evidence, so this motion is granted. Okay, so yeah, that was a motion that was granted because they claim they're not going to use it. Yeah, we already went over that. Alright, yeah, so that's the only update per Thugger Daily. And like I said, he definitely keeps up with all things YSL. So if y'all don't follow him on Twitter, make sure you follow him on Twitter. Because I'm going to be honest, a lot of the YouTubers that cover the YSL case, even the attorneys, okay, that cover the YSL case on YouTube, they go holler at Thugger Daily, okay? He gets all the paperwork when it comes to YSL. And I don't know his occupation, okay? But if he's paying for it, that is a costly thing, okay? Trust me. It's like, I think Fulton County charges like $1.06 per page. So, whew, okay. I remember them days of buying that paperwork in the beginning of the YSL trial. For those who don't recall, I used to cover the YSL trial when it first came about. However, when they started dragging it out, I got bored of it and I started covering other things, and then which ultimately led me to cover the O-Block case. But yeah. But we're back at it, okay? Like I said, just to let y'all know, starting tomorrow, I think we're going to get back into topics and then probably watch the trial maybe the second half of the day, or we can watch the trial the first half of the day, catch the vibes, and then the second half of the day do topics. Okay, so I don't know which one we're gonna do. I guess we can kind of go with the flow. But yeah, now Monday is supposed to be when trial is back in session, meaning the jury is supposed to be back. Kenneth Copeland, aka Lil Woody, is supposed to come back, and depending on how he wake up, his words, not mine, will determine if he's gonna continue to testify or if he's gonna plead the fifth and refuse to testify, which is gonna get his ass locked the fuck up. Okay, and as the judge stated yesterday, they can only hold him until the end of this trial, which some of us think it shouldn't be too much longer. Like at any point, it's gonna be a mistrial, but it can take up to next year because obviously this ain't just like here. I will say the defense has tried, okay? Has definitely tried every little thing they can, every motion they can think of, they have filed it. But again, like I said, I don't think the mistrial in regards to anything with that ex parte hearing was going to be sufficient because it wasn't deemed improper technically, right? We all think it's improper for sure, but it wasn't deemed improper by the court. And with that, you know what I'm saying, that's going to cause it to be, you know what I'm saying, more hard for you to say it was a issue if it wasn't even deemed improper. So that's why those mistrial motions have ultimately been denied. Now, the two mistrial motions that still out, one is from Harvey and one is for Short, if I'm not mistaken. I think those are the two mistrial motions that still are at large. So what I want to do, I want to tap in with lead attorney. Y'all know I like to watch lead attorney. He's funny. He can go left sometimes. So FYI, I just wanted to see his take because he's actually a legal lawyer. So I just wanted to see.
And that's fine. You don't know. Black Lady Love has been withholding evidence. In fact, the other judge, Judge Glanville, who was
talking about it.
Market, he even had to get on Black Lady Love about turning on that.
Y'all know I call her Lion Love.
He reached up a point where he was so fed up, he told Black Lady Love on the record that if you fail to turn over any more evidence, there will be consequences and sanctions. What does sanction mean? Punishment. Attorney Westmoreland stood up and said, Judge, I know you're trying to cut her some slack. The previous judge had already cut her so much slack and then stopped it and said, if there's any more evidence that you haven't turned over, there will be consequences and punishment. What has happened now, Judge? She still has not turned over evidence.
That's why she's going to keep doing it.
She knew about this in January, and she sent it to us last night.
That's why she's going to keep doing
it. Hold her feet to the fire and give the same consequences and repercussions that Judge Glanville threatened her with. What did Whitaker say? Well, I'm just getting into the case, and this
his damn impersonations be funny to me.
The judge said that in terms of any other future discovery violations, any violation that she catches in the future
is done.
She said that there should be in the future maybe 0 violations going forward. Maybe 0 violations. What does that mean? Maybe 0 future violations.
Meaning no more, Lee. No more.
It means, Judge, if I'm being honest, you're kind of cutting her some slack.
Definitely.
Jeffrey Williams, a.k.a. Young Thug, a.k.a. King Slime, his life hangs in the balance, and you are cutting Attorney Love slack on discovery violations.
That's true.
King Slime has state constitutional rights. King
crazy.
Slime has federal constitutional rights, but you are giving Love slack. Well, I know you guys think I'm being patient, and I am being patient. Well, why? Somebody write in the chat, why? Why is everybody being patient with this woman?
Mm-hmm.
The other judge in Baldwin, did y'all see that? That white judge
wasn't playing.
Baldwin shot that lady through the chest. And Baldwin really didn't care. Did y'all see Baldwin? Y'all want to know what's fucked up? Baldwin shot Alec Baldwin. I'm talking about the famous.
I'm gonna let him ride. Come outside. I tell y'all, league can go left sometimes.
He shot that lady through the chest. When they did his interrogation, do you know what he said? He said, yeah, you know, I shot, the bullet went through the one guy. It went through the lady, and it hit the guy. And the guy was talking, and then, but when I looked at the lady wasn't talking. She had been shot through the chest. Baldwin said her eyes were rolled back in her head, you know, blah, blah, blah. I was like,
oh, wow.
Imagine shooting someone through the chest.
I need to watch his interrogation. What the hell?
Blah, 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 blah. He didn't care.
Oh, wow.
He did not care. Alec Baldwin was on trial for homicide. What did the judge do? Anybody know what that judge did?
Threw that case out.
The judge caught one discovery violation. What did the judge do? Mistrial. Mistrial without prejudice.
I mean, they can't retry.
That mistrial with prejudice. What does it mean?
Alright, shout out to lead. Yeah. That judge was not playing. I don't know what this judge got going on. I just knew today was gonna be the day with that one. But like I said, Love got herself out that hole. I thought she said 12:30. They 2 minutes late. I'm at 3:30. I keep forgetting my computer is on West Coast time. I need to fix it because it be confusing me sometimes. Oh yeah, y'all, I'm sleeping. I am sleeping. I'm gonna try to give y'all one more content video today. I'm gonna try, but if not, y'all get one in the morning. Y'all know I have been breaking down the Julio Foolio murder investigation paperwork, and yeah, I think I got 2 out the way and more to go. But y'all may get another one tonight or probably just in the morning, one or the other. But yeah, we just wait for them to come back. Like I said, it's gonna be a lot of litigation for the next couple of days in preparation of the trial resuming on Monday with the jury. But until then, like I said, we either going to do half days of the trial unless some real juicy stuff happens, and we'll do the full day starting tomorrow. So tomorrow and Friday. And then topics. Because, while we're sitting here waiting, just a little side note. They said Nelly has been arrested for not having car insurance and having 4 ecstasy pills. I was like, damn, he couldn't just swallow it? Like, what the fuck? They're going to jail just for little if Kodak said he used to do, how many pills Kodak said he used to do? Whatever amount of pills Kodak said he used to do. But yeah, it's on the local news out in St. Louis. It says rapper St. Louis native Nelly arrested Wednesday morning. The St. Louis icon was arrested around 5 a.m. Wednesday near the Hollywood Casino. Nelly, whose birth name Cordell Hayes, arrested around 5 a.m. by the Missouri State Highway Patrol Gaming Division at the Hollywood Casino on a failure to appear warrant from 2018 out of Maryland Heights. Boy, you know that's some bullshit when they pulling up some old ass warrant. Okay. According to online arrest records, the 49-year-old was also in possession. Okay, hold on.
Dive into what I think is going to be our task for the rest of this day, which is going through the other statement, the 20.
Ah, shit.
I don't know what date. What is the date of this?
August 5th, 2015.
Okay, the August 5th, 2015 statement of Mr. Zachary and potential objections to that.
That's so many statements to have from one person, for sure.
Is there going to be a 4:30 to 4:45? Hey, Judge, guess what else happened?
Okay, like yesterday.
Because if so, go ahead and tell me now.
I'll go ahead.
is not a disappointment. Okay, so where are we on, and I know we've got all day tomorrow. I don't know if I have told y'all or not, Friday morning, we will not be in session. I think I mentioned that I had a conflict and that I just didn't know with regard to Friday afternoon, and we probably will make that call a little later. I mean, hopefully we can have a really productive day tomorrow and we can have Friday off from active court, and then have the jury on Monday. But I still need from y'all, if you want some kind of a 105 limiting instruction, that contingent type instructions for our various scenarios we might face depending upon Mr. Copeland's Monday morning decision about whether to take the stand or not. And then if he is going to take the stand, I think y'all had said everybody's happy with, well, not happy with, everybody is in agreement that what he then said on June 7th, 10th, and 12th prior to the motion to recuse is fine and is in. So with regard to after the motion to recuse, and it sounds like, honestly, there was kind of almost a clean break with regard to prior to the motion to recuse, he had not really gotten into any of the testimony concerning the Donovan Thomas murder or questioning about that. And of course, honestly, I bring notes up and then I don't know what happens to them.
We're gonna see where they going with this, y'all.
And that, does everybody agree that basically, I mean, I think it was like on the, I don't know, because I wrote it down, now I can't find it, but that none of that was before the motion to recuse. Everybody agree with that?
I agree, Your Honor, there was definitely a clean break.
Yeah.
And the majority of the days after the motion to recuse consisted of.
There's nothing more powerful.
I doubt he's gonna testify. My opinion is Woody's gonna testify. He getting to the bag too much right now to throw it away to go to jail. So he's definitely gonna testify. So, in my opinion.
There were questioning and the video audio of the early morning hours of January 11th, 2015, recording with Detective Thorpe, Thorpe, and Mr. Copeland was played in its entirety for the jury before the motion to recuse was filed. And then there was a second audio video, January 20th, 2015, that was also played.
After. Did you say January?
Yes, it's hours after the government killing. The killing is January 10th,
right.
7:22 p.m. 2015. Early morning hours of January 11th, Mr. Copeland is with Detective Thorpe.
What it do? Miss me with that BS. Y'all make sure y'all subscribe to my girl. Miss me with that BS.
January 20th.
January 20th, not February 20th.
Well, no. There's maybe January 21st. There's a 2 in January, 2 in February.
Right.
1 in.
Well, anyway, whatever those two statements were, somebody can go back in the record and look. But that was most of what occurred afterwards.
Before the filing of the motion to recuse. That's what I'm trying to articulate.
All right.
There was discussion of Donovan Thomas before the motion to recuse. That's why I wanted in. There's a lot of exculpatory information.
Okay, so y'all can agree to whatever you want to agree to in terms of things that are before the jury post recusal motion.
That's gonna be so confusing for the jury.
Pre-recusal motion, that's why I wanted it.
Recusal motion.
Yes.
Okay.
There's no, we don't have differing opinions about pre-recusal motion as long as he continues to testify.
Mostly, yeah, but she got her own issues.
So, yes, so whatever, if he continues to testify, whatever.
But for the most part, she already
been tackled pre-recusal is fine. And you were saying that part of that, there was at least one, maybe two videos played pre-recusal.
That's true.
Okay. And so those videos, y'all, was it like the entirety of it, or?
Yes, it was. We sat here and
It seemed
listened
to
to
be
it.
most of the day's transcript was video played. But,
It was, Judge, it was.
but then video was played on the 17th also, which was post-recusal, right?
Yes.
And that was maybe, I thought maybe that was January 11th and February 20th. Okay.
Yeah, that was so draining those days listening to that. Because remember, we hadn't already listened to it on the other days, and we had listened to it in real time. That was a lot. Mm-hmm. What's so crazy is I see all these parents. Some of y'all parents must got some. I mean, damn, some of these kids must be bad as fuck. Cause all I see on Facebook is why they shut down the schools. Cause you know we got a lot of rain. It been raining. It seemed like for 10 days. It's supposed to rain for a couple more days, and they mad as hell about them kids can't start school tomorrow. I'm like, damn, y'all kids must be bad as hell. Y'all want them to get on the regular ass roads, on the regular ass buses, knowing half these roads falling apart already. Kids must be demons.
Those were played prior to.
Yeah, no, I'm asking about afterwards. I am asking about before and after, I guess. I thought on the 17th, which is obviously after, that the January 11th and February 20th video statements were played.
I believe that is correct, and I'm making sure. That was my memory. My memory was that the full video, she played portions of videos prior to that, 17th of the last.
Right, but some little snippets, right.
But the full videos were not played, and that was what the discussion internally is trying. I thought that was what we came to, that the full videos were not played until after the motion for recusal.
Okay.
And the questions that led to that. So there were questions, and then there was the playing of the videos.
Okay.
January 11th played, and January 11th and February 20th
Yeah,
were played on 6/17. That is true.
okay,
There were snippets before that in discussion before.
all right. So, in general, in terms of an instruction to the jury, a couple of different things. All right, yes, the January 11th and February 20th videos were played post-recusal motion. The contents of the January 11th and February 20th videos are not going to change. Are y'all proposing that we have the jury watch the entirety of those again? Simply because they watched them after the recusal motion? And I'm just asking that because I'm trying to figure out the logistics. And y'all can huddle on that if you want and give me an answer tomorrow. But in terms of thinking through how we instruct the jury and how we handle this, that is an issue to be considered and for y'all to come up with an answer about, okay? And then, is there, other than those two videos, however y'all want to handle those, is there other testimony, questioning and answer, testimony that y'all want to come to some sort of a stipulation about? And yes or no, either of those is fine. Just, I need to know how to deal with it. And then if no, then is the instruction going to be, was there anything substantive about the Donovan Thomas murder prior to the motion to recuse? If there really wasn't, then I can say that we're doing everything about that over again. But if there was, then it needs to be a more nuanced instruction. So y'all, I would really like those by tomorrow so that we can discuss them. And okay, because, all right, okay. And then it would be nice to have the 105 proposed limiting instruction by then as well. But I'm certainly not going to give it before I get a proposed one. So that's kind of on you, Mr. Hardy.
Your Honor,
Yes.
we had addressed in writing and will, if necessary, if the court tells us to address in writing again, that a 105 instruction in a RICO case is not
So if you want to you don't have to refile the same thing, just point me to when and where it was filed. But yes, I know that everything gets to be considered that is alleged as an overt act in furtherance of a conspiracy, a RICO conspiracy, and a RICO count. What I am contemplating instructing on is something to the effect of, everybody here is charged in count one. Anything you hear that's an overt act can be taken into consideration when considering whether the state has established guilt as to count one, as to each of these individual defendants. With regard to, whatever count it is. If we're talking about the Donovan Thomas murder, that evidence can only be considered as to the people charged with it when determining whatever those counts are, 2, 3, and 4, or whatever they are.
What it do, Skull? Shout out to Just Say No to Skull. He be popping his shit every night.
Considering everything against.
Tired or not, I always tune in to his live.
Instruction.
Y'all make sure y'all subscribe to him. If y'all have not, I know all y'all know who Skull is.
Oh, I know. And so it is 100% appropriate for the jury to consider that evidence when considering count one against each of these defendants. It is not appropriate for them to consider it in terms of the guilt of any of the defendants to any other counts, other than the people who are charged with the murder and the corresponding whatever it is, ag assault or gang or whatever. Okay? So that's my thought as to that. And y'all work on well, Mr. Harvey is gonna take the lead on, and then I'll listen to objections on, and I'll formulate some. But I think that that is appropriate upon request, as long as it is an accurate statement of the law. Okay? All right. So, that all being said, let's now turn back to the scintillating task of how to redact this statement. Laura, can you make
There's no R in affidavit. You spelled it with an R. Thank you.
Miss Love, I asked for my stapler back, Mr. Atkins, and it is not back yet. So, I mean, I'll leave it to y'all again.
Yes, Your Honor. Thank you for letting me borrow it.
Okay. All right. Everybody ready on our
Now, what statement they about to do?
August 5th, 2015 statement that we need to get through? I'll take the silence as a yes. Okay. All right. All right.
What's
So,
up, Pat G?
Mr. Shard, if you could do us the favor of making your proposed redactions another part of the record somehow.
Would you like me to put like the heading, the title of the case, and style of case on it?
I mean,
Make it look official. I didn't file them in, obviously.
it can just be a notice of filing, and you can do a cover that says notice of filing of, whatever, and then just attach this. It's fine with me. I'm not really that particular about how it gets done. I just want it to be a part of the record.
Yes, sir.
Okay, thanks. All right, item number 1, page 24 is where we start.
So, Your Honor,
Yes,
in regards to the state's position here,
yes.
it is not, we are introducing this kind of like what the court alluded to earlier.
Mhm.
It is important
Oh my
that
God.
the YSL members believed it was If Gang. Whether
Right.
If Gang actually did the shooting or not, what happens immediately after this is
So was If Gang ever on a RICO, or is it not an If Gang no more?
So it's the fact that they believed it was If Gang, whether in reality it was or not, which came from Summer Good, who was Cordelia
I need to look
Sackman's
that
at the
up.
time girlfriend.
Okay. Oh, and let me ask, actually, are there any of this list of 43 items that the state agrees should be redacted?
Yes, Your Honor.
Yay. Tell me what those are.
I wonder if I wonder. Because the way they be talking like, well, why the other side? Normally they do both sides.
There's one that references the Sandy Springs search warrant of defendant Williams' house, that's out. I'm trying to figure out what number that is.
Okay.
Don't forget to subscribe to the channel. We are on the road to 20K and we are almost there.
Mr. Sharp, do you happen to know which item number that was? Sandy Springs search warrant?
We are almost there. I think we at we need 150.
I did more than that one.
Definitely gonna get there by the end of the month for sure.
There's also one where I'm finding this number, Your Honor, but there's a
141 left
this
to
is
hit
accurate
20K.
says that defendant Stillwell is hot-headed. There's a part after that, but the state agrees that calling him hot-headed,
Okay.
the state would concede that. So I'm gonna find, I have this in order, but
Okay,
I can
so
separately draw out which ones.
it's fine. I guess just that whenever we get to it,
Yes, Your Honor.
you can say before I read it and Mr. Short argues, just say, okay, for that one, we agree.
Thank you.
All right.
The first one that Mr. Atkins was referring to is number 34 on my list, I believe, which is 149 page 149, line 19.
Okay.
That's correct, John. Thank you, Mr. Sharp.
All right, perfect. Okay, so back to number 1 then.
Yes, Your Honor. So, as articulated, the state's position here is it's important that they believe that If Gang was who shot at Demikian at Club Crucial, because after that, Kadarius Zachary, Antonio Sledge, Demikian Garlington, and defendant Stillwell, they get into a vehicle and go and shoot 1428 Adele Drive, 1903 Drew Drive. And so it's in result of If Gang shooting at them. So I see the objections here say about who did the shooting at Demikian at the club. And so the state's position is it's the effect on...
Right, you're not offering it for the truth of whether those people did the shooting. You're offering it for this.
Well, you fun. I had to look at your comment again like, what
Yes,
is
Your Honor.
All right, any response?
I believe that it's hearsay. Mr. Zachary was not present. I heard what the state said. My stance is Mr. Zachary was not present at the club when Demikian allegedly got jumped, and he wasn't outside the club when shots were fired. So any information about what happened outside the club that day was something that Mr. Zachary does not have firsthand knowledge of.
All right, and so essentially 24 and 25 relay a lot of, I guess, details about who did the shooting.
Yes.
Yeah.
Outside the club earlier that night.
All right, so and again, all of this is if he, if you have to impeach him because he is not testifying as you thought he was going to consistently
definitely have to impeach him.
interviews.
He's gonna be a difficult witness.
If you are then impeaching him, and your purpose is, hey, at that time you told us, it needs to be phrased in a way that what you're impeaching him on is not A, B, C, and D people committed this. It's you thought at the time it was this, right? And so I don't even know that you need to go through 2 whole pages of that to accomplish that.
Yes, Your Honor.
Okay, all right.
Understood. And agree that's the state's intent with this portion.
Okay. And I'm making all of these rulings prior to us coming back with these witnesses on the stand in hopes of there being an understanding by everybody what comes in and what goes out, and us not having to take it up while the jury's here. But if for anything, at the time we arrive at it, it looks like, okay, this is not what we agreed to, or this is not my understanding, don't just sit mute. I mean, raise it to me and say, remember, Judge, you said we didn't need to get into all of these details. It was for the purpose of, y'all believed at this time it was IF, okay? Are y'all on notice of that? Okay. All right.
So, Your Honor,
Yes.
the second one, this transcript is very incomplete. So,
Yeah.
could I'm sure Your Honor can flip to the page, but it's probably not going to help. May I convey what I believe?
Absolutely, and that has been helpful to the extent that both sides have done that so far. And from the portions that I have listened to with the transcript in front of me, watching the videos, the transcription is less than stellar. So yes, please do. Please continue to do that.
So on page 48, line 7, Quindarius Zachary says, and he and Thug, like, nah, I ain't cool with N's, the N-word, until they pay for my window.
Okay. Until they pay for my window.
And then it says woman, and I believe that's Investigator Gaither says, but why they shoot up the dugout? And then Mr. Zachary, Woody and Kel had something personal going on, I guess, who was big and bad? And my objection is with the statement that Mr. Williams, according to Mr. Zachary, said, nah, I ain't cool with N-words until they pay for my window.
Okay.
I don't have any understanding or belief that Mr. Zachary had any firsthand knowledge of any conversations that Mr. Williams may or may not have had with other individuals about this subject. And I think he's just passing on information that he's heard.
Your Honor, the state's response here. So, just to give a little context to Zachary at this gambling house, Zachary says, "I was inside. I didn't have a gun on me that night." And the way he says it, in the state's opinion, is with that when defendant Williams walks outside right before, who they later go on to believe Kelvin Watts, Shell Kell, shot and broke his window, that he kind of comes outside afterwards. I mean, so
Zachary?
Yeah, Zachary's inside when the shooting happens. So he's not physically outside. He doesn't like spot Shell Kell in the bushes and say, "Oh, I saw him with my own eyes." But it's kind of the state's, with the way he describes it, you know, he walks outside soon thereafter because he just heard a bunch of gunshots. Right. And I think it's reasonable to believe that, you know.
Ah, shit. Oh. About to bust my ass in these damn bedroom shoes, moving from place to place. Y'all hit the like button for me and subscribe to the channel.
And this is relation to something else that comes up down the road where a female who Shell Kell ends up confiding in, Zachary classifies it as flexing, like bragging about doing the shooting. That's how they end up believing or thinking that he did that, to confirm that. So when he says here, you know, he's
where the hell is a Shell Kell at now? Is he in jail?
Reaction to the window.
Has he been
I
in
think he
jail?
has.
We might need to look him up.
Reasonable assumptions, I believe, that given his personal being there, interacting with this individual on a regular basis, and also the key part that Kelvin Watts is the half-brother of the deceased Donovan Thomas. And so I'm not saying that the murder of Donovan Thomas was 100% related to this broken window, but it is, you know, relevant in that sequence of events and escalation of shootings in the state's position. So with all of that said, the state feels that this is not as speculative as it may first seem.
All right, and you
he already in
evidence
jail.
somewhere else that Zachary walks outside while the aftermath of it is still going on.
In his interview, Your Honor, he ends up saying, so everybody's walking him to the car, him being defendant Williams.
Okay.
Gunshots still going off. And
I
so
think he in jail.
I'm still gambling. I didn't have a gun anyway on me, so no sense walking him out there. So Zachary tells the police in the same interview, I was at the gambling house, and then he says, then gunshots go off, and then everyone runs out the door, everyone in there with guns ran out, started shooting. So like he kind of alludes to, after this gunshot, everyone in the house ran outside.
If he says everyone with guns ran out, that does not include himself.
Yeah.
If he just said he didn't have a gun. So is there something more?
So, Your Honor, he also goes on to state that a bunch of people were, he's inside the gambling house, he's posted a bunch of pictures, Instagram photos, and he says, when the windshield got shot out, did they confront Kell about it immediately? Zachary says he didn't know because they didn't initially know, have to find out down the road. And so I'm trying to find where this is in terms of, he says, you all come outside. Zachary says, I didn't have a gun. And so there's other, I guess, evidence, so to speak.
Oh,
in some of
damn.
Copeland's interviews, taking aside what's in evidence right now or not, with what we're redacting, he describes this gambling house incident as well. So for purposes of, in this hypothetical universe, defendant, or not defendant, but Mr. Zachary's going to testify after Copeland.
Okay.
And so the state believes that with the combination of, I can't find in this moment, Your Honor, where Zachary himself walks outside, but he does state in this interview that there was a lot of gunshots, it was chaotic, people ran outside. I think it's fair to assume he walked outside at some point shortly thereafter, didn't just stay gambling after they shot up, and he interacts with these people on a nearly daily basis or a frequent basis, that this shooting of the window is something that gets referenced by multiple interviews.
Yeah.
So it's the state's
I know he ain't in jail no more.
evidence where he's like, this is exactly how I know, but I think it's reasonable to think that he would have a pretty good basis for what he says in this specific clip that we're arguing about. And also, when he says, a part of this as well is Rudy and Kel had something personal going on, he interacts with Mr. Copeland, who his nickname is Rudy, and so I think he would have a foundation to know that Kenneth Copeland and Shell Kell did not interact.
And I'm not even honestly sure that when he's saying that Doug says, no, I'm not cool with them till they pay for my window, that he's necessarily, that the assertion is necessarily that is what Mr. Williams voiced to anybody that night out in the parking lot. It's just...
So, my understanding, based on what Mr. Copeland has stated in this courtroom, whether it's in the evidence right now or not, there's a shooting at the gambling house. Shell Kell was not initially thought to be the person, and then later has pillow talk, and he's thought to be the person. I agree that Mr. Zachary was present at the gambling house per his own words, but this conversation about I'm not cool with people until they pay for my window never is alleged to have happened that night. There's a subsequent conversation with Mr. Copeland, and Mr. Copeland is apparently there, and Mr. Watts is apparently there, and allegedly Mr. Williams is on the phone with Mr. Copeland. That's Mr. Copeland's testimony. Mr. Zachary, in my understanding, has nothing to do with that conversation. So he is passing on hearsay that he would have heard from Mr. Copeland, presumably, but that's, I'm speculating.
Okay, well, even if it's hearsay, I think this would come in under the, and what's your theory as to why this comes in? If he hasn't heard, I mean, if you can
Damn, did he
show
beat the
that
body?
he at some point heard or overheard Mr. Williams saying, they can pay for my window and then we're cool, not until then, great.
Yes, Your Honor.
Point that out. Otherwise, it is hearsay. What would the exception be?
So, Your Honor, the exception here would be, or at least the state's argument is that, and I can't directly point to the moment in time where he believes or hears someone state, I'm not going to be cool with him until he pays for our window. What I will point out, and I will, in answering the court's question, is shortly thereafter, in this interview, Mr. Zachary says, Thug comes in crucial, throws money, Kel doesn't want him to do that. The Thug, he's not clicked with him, or it may be cool with him. He didn't like them. They shot at his window. So he later on in this interview states it definitively that, like, he doesn't like them. They shot at his window. Okay. And so the state's position is that for an exception, and again, I don't have direct evidence of which individual told him this, but the state's just given this event of the window being broken repeatedly being brought up by either defendants or co-conspirators in relation to this, and it being a somewhat significant event that it's reasonable to believe that this is either a co-conspirator statement that was made or something that he has a good faith basis to believe that defendant Williams does not like Kell because he, and what Mr. Copeland says on that is basically Kell's like, I'm not paying for the window. And so it kind of ends on that note.
Yeah.
So I don't have a definitive moment in time, but that's the state's position on that in terms of Zachary making that statement.
Right. Okay. I mean, yeah, I would think that this could come in under 801D2, maybe E or yeah. Or A, really. Okay, so that is going to be admitted over objection. Yes.
Number 3, Your Honor, is Mr. Atkins kind of leads us to number 3, which is the conversation that he just referenced. Mr. Zachary, and you don't get this from the transcript, but he says, I'll start at the top of page 49. Zachary says, you know how they do, Kell wasn't like thug coming crucial, giving out, throwing stuff. Kell didn't want them to do that. And then Gaither says, right. And then Mr. Zachary says, yeah, Thug wasn't, he ain't click with them like he didn't like them. And then Gaither says he ain't like Kell shot out his windshield. And then Zachary says
okay, Blue, no more.
My objection to this is that he's testifying to the thoughts and feelings of Mr. Williams, who Mr. Williams likes, who he doesn't like, and to the mind state of Mr. Williams. I don't believe that that's appropriate.
All right, so the throwing money parts as to the incident that happened at the club.
Correct.
Right, where some people.
And for context.
Right. So is Mr. Zachary there, or does he know about that incident having occurred?
So, Your Honor, there is there's specific incident reference where Mr. Copeland gets jumped at the nightclub after flashing money, but in Mr. Copeland's own, and maybe in other statements, but certainly Mr. Copeland, he kind of regularly went to Club Crucial and flashed money.
Okay.
And so they kind of referenced that Woody flashing money in Club Crucial was not like a one-off event.
Right.
And so the way I take some of this, what he's saying is, they come into Club Crucial almost every Monday or every other Monday or frequently, like to come to that same establishment where a lot of Kell and his crew, which is the If Gang, and the YSL are there at the same time. So with that, I just wanted to clarify that for the court.
So who's the he that we're talking about then in 49, 1 through, I don't know, 8 or 9, where there's a he didn't want me doing that, he ain't clicking on me.
They're talking about defendant Williams, like.
That's what I thought.
Yes, Your Honor.
He ain't clicking with them.
With
the opposite side.
Okay, well, so that's just mistranscribed.
Yes, I believe so.
Okay. Okay, so y'all are going to or have established that Mr. Zachary also has a close relationship with Mr. Williams, right?
Yes, Your Honor.
Okay. He's got basis to know those things. So,
I'll be like, none of them niggas know me, bro.
I'm going to withdraw number 4.
Okay.
consulting with my colleagues, we're going to withdraw number 5.
Okay.
Okay. All right. Then, number 6, Your Honor, is talking about, and this came up in I think the last statement as well. They were under the belief that NBC did the shooting at the dugout, the false belief, and they're talking about why did you believe that? And he's saying because Yak, Mr. Kendricks, beat up someone at the club. And specifically on 55 line 17, if I can make sense of this transcript, they said they didn't mess with each other. They didn't mess with each other. So it was already tension in the air, but they waited until the boy Yak, he had gotten into it with MDC and DC, and I had helped him fighting in the club. So y'all got into it, some guys from MDC. MDC is down with who? They from Bankhead.
Down from Bankhead.
And then they say, so Miss Gaither and Michigan, that's what I'm saying. It's like they not really with, and then Mr. Zachary says, if gang, and Gaither says it's just them themselves. Okay. And this has nothing to do with,
All right.
It's just bringing up a fight that Mr.
I'll send you an email on Midwest what to do.
Allegedly that.
Because you never really explained what you was trying to do. I wasn't really clear on that, but I'll read that email again.
All right. So, Your Honor, the state's position with this part is it has a couple relevant portions. One being state has to prove association. And the fact that Zachary is defending, he's like, I get in the fight too with the MDC, which is the most dangerous clique, a gang on the west side of Bankhead at that time. The state's not going to be belaboring the point about this one fight and trying to cast anything improper, character-wise or what, about a fist fight in a club. But the point of this is that they defend each other, and that's a big part of the retaliatory shootings. This is a fist fight, but the fact that he jumps in and protects him, and also the way he describes this in the state's position is, he says, like, Detective Gaither, Zachary's like, they're from Bankhead. And Detective Gaither is like, that's what I'm saying, they're not really with If Gang. And Zachary says they're just their self, like they're not a part. So he has some familiarity with street gangs and who is clicked up, so to speak, with who. And so the fact that he's talking about and he's saying, like, to me, there's a we and an us. There's not much else that I've seen in this case file about MDC, but that part is important.
Okay.
Another part about it that's contained in this, I believe, is this gets down the road to where how they learned that Shellkel was the one who claimed or did shoot Defendant Williams' window. And so he says he ran his mouth to a female who goes by Gucci Red. And so, again, the key part of this is that's how they end up believing that Kelvin Watts did the shooting, because they initially thought it was MDC because of his fight. So the state believes this portion is relevant for a number of reasons of why they initially thought it was MDC, the association between Zachary and Kendricks, and also there's a part, at least if I'm reading the page 55, line 17 to page 57, line 7. My apologies, Madam. To page 57, line 7 includes what on its face seems hearsay. Like they learned about this from this female, but it's important that they believe it was Shellkel who shot the window.
And I think we've made the decision as a defense that we're not going to fight the hearsay about it being Shellkel and how that eventually came about, and that would be on page 56, line 10 to 19. It's he's saying that they found out it was Shell Cal because he was running his mouth to Gucci Red. He says pillow talk and junk. So I don't have a problem with that section. I just don't know why we need to get into Mr. Kendrick's apparent simmering feud with completely unrelated people that led to the false belief that it was the most dangerous clique as opposed to Shell Cal. I mean, we can just get into the fact that they know it was Shell Cal now without going through that whole misapprehension.
Okay, so, I mean, it is potentially relevant, again, this is only if he testifies inconsistently, on the issues of, as you represented, what you think it's important for is that, hey, we all defend each other. We hear XYZ, and then that's good enough for us. We go back our boys. And what was the other thing you said? I mean, I think it can come in for that. And then, as to, they've withdrawn the objection to how they end up finding out it's somebody else. So, okay? And so, again, as I said with regard to the very first one, this does not mean that you then have license to play these whole 3 pages. You just need to make the point in the part that would make that point, okay?
Understood, Your Honor.
All right. Okay. So turn into item 7 on page 59.
This is them talking about the dugout shooting and them finding out it was Shell Cal. So I'm going to withdraw that.
All right. All right, item 8 is bottom of 60 through middle of 64. And give me just a second to take a look through that.
I looked up Calvin Watts. Calvin Watts got a long background. He was even picked up for murder, according to the Atlanta News, of a young lady back in 2015. So 2015 was a hell of a year, obviously, in Atlanta. But I don't see that he's in jail. So I'm assuming something went in his favor for that murder because he ain't in jail. He got out in 2019
listening to it
for some other charges.
Because there is some Scribner's errors a lot in this portion.
Okay. Dad, you have it queued up?
I am, Your Honor. We're getting queued up right now to play.
As a general proposition, this is my understanding of what Mr. Zachary is saying.
Speak into your mic.
Mr. Zachary is saying throughout this process that my client told him some information.
Okay.
That information included 4 people that were in the car. That's what Mr. Zachary is saying. Mr. Zachary is also saying that Mr. Kendricks said something to him, which was that involved the 4 people in the car, according to Mr. Zachary. later on, he goes into more detail, and this is starting on 63 line 8. He goes into more detail about an entire story involving cars and cars driving by the Texaco, and spotting Donovan Thomas and switching seats with Bushi and all those things. My understanding is Mr. Zachary is saying his source of knowledge on that is Mr. Garlington.
Okay.
So my objection is that anything that didn't come from my client would not. I understand statements by a party opponent as it applies to my client. If he's saying my client said something to him, I understand that, and I'll deal with that through cross-examination. But regarding things that Mr. Kendrick supposedly said to Mr. Zachary, or that Mr. Garlington supposedly said to Mr. Zachary, I'm objecting as on hearsay and confrontation clause grounds.
All right.
There's no confrontation clause issue because it's not testimonial, but so the way, and we'll play this, before he gets into this portion,
I don't know why I keep tripping every time I get up
Shannon
in
Yak.
that.
Yak is defendant Kendricks.
Okay.
And then he just kind of goes into after that, they're like, why'd they tell you? We were at the house talking about it. And for the next, couple minutes, he just starts providing details. So it's not exactly clear.
Right.
But also what's important, Your Honor, is he also later on in this interview, and there's some social media that backs this up, that
Shit.
Mr. Zachary, Defendant
That's social
Stillwell,
media.
Ken Copeland, Demise McMullen, who they call Nard, Defendant Williams, they go in a Sprinter van down to Miami, Florida.
Right.
So they have some statements about Defendant Williams had a concert there. The state also believes views as some consciousness of guilt getting out of the city after the murder, because Donovan Thomas is January 10th, and they start traveling down there January 11th. And so all that aside, the state feels that him, the night of the murder at Defendant Williams' condo, them directly telling him, obviously that's a party opponent admission, but the state feels more so it's a co-conspirator statement.
Right.
To keep him abreast, they all travel together as a group down there. And then, so that's the state's position, is that this entire portion is a co-conspirator statement. It's keeping them abreast, it's cohesive, and he needs to be aware, because what happens that same night is if gang members and their associates start shooting YSL houses up. And that obviously escalates.
All right. And I think that my ruling with regard to this piece of the statement is the same as it was with regard to the similar statements in the April 2017 interview or statement, and that is that these are statements by a co-conspirator, and I believe sufficient evidence that they're during the, in furtherance of the conspiracy and still in the concealment phase. So I'm going to admit those over that objection, and with regard to the confrontation clause objection, these are not testimonial as made to Mr. Zachary. Okay. So item 9.
Item 9 honestly would fall under the same
Okay.
ruling that you
All right. Thank you. So item 10 is on page 66.
Your Honor, I believe this is just a single line of Detective David asked Zachary, did Woody, Mr. Copeland, have anything to do with not being killed? And he says, nah. And the state, it's listed as speculation.
And based on the fact that everybody's there right after the murder talking about it.
Correct, Your Honor.
Okay. All right. On that basis, I would permit that. All right. Item 11 is bottom of 66 through mid 69. An objection is hearsay. Is this going to be the same concept or something different?
It is.
Same.
It is, but within it, so I will, over my objection, I understand.
Yes, and I understand you still have an objection to it, but.
Now, I will point out on page 67, line 18, they say, why not? And Mr. Zachary says, I don't know, they just, I guess they just wanted for them to do it instead of Moontook and Woody. So he's speculating.
All right, let's strike 18 and 19.
They mentioned Zachary mentioned Woody like he was a hero.
Speculation.
And then she Gaither follows up like they wanted to do it themselves.
Oh, okay, so 18 through 25, really. Right.
Well, and then he says not to get them a name. He's speculating as the reason why they just want to get a name for themselves.
Okay.
All right, so I'm looking at my notes. Line 2 on page 68 says like to get them a name.
Okay. Okay, well, yeah, that's also speculation. Unless you have some basis for it being something other than that.
So, Your Honor, the state's argument on this portion is when he's talking about getting a name, it's very integral to the state's position of how gangs work in terms of trying to move up in rank.
Yeah.
Later on talks about so the state believes that his quite frequent interaction, he does state expecting things. I'll be upfront with the court about that, but I do believe that in terms of they ask him why, and the court may say, hey, Mr. Atkins, it's speculation, it's out. But my argument on this is that his frequent interactions and, there's evidence that will come out either through impeachment or some other way that he has participated in crimes with them and is familiar with who he's speaking about. His thought process on motivations or what was going on in terms of a gang context is appropriate. That's the state's argument.
All right.
Now, I believe the state has, I know that they've called experts, and I believe the experts have touched upon people, quote unquote, the term that the experts like to use is putting in work, and they've talked about that.
All right.
The state, I'm sure, is going to argue that. So I'm not saying that, obviously they can do that, but they can make that argument, but for Mr. Zachary to affirmatively say that's why other people did something.
Sure. Okay. Let me make a ruling with regard to 67-18 through 68-2 that if you cannot get this in as speculation as to why XYZ people might have done this murder. But what you can do is if you ask Mr. Zachary, is a way for people to move up in a gang to commit crimes, and he says no, then you can ask him about that particular concept. And him having said before, well, you know, not with regard to a specific crime, but you're being asked about a crime, and you're saying, well, maybe it was to, okay, understand, everybody understand?
Understand, Your Honor.
All right. Let me write myself a note on that. And the rest of it, if the rest of it is just kind of the same basis of knowledge, co-conspirator thing, or is there more to it than that?
More to it.
Okay.
So for the rest of 68 to 69, line 11, it's discussion. I don't know if you've heard us talk about this yet in this case, Your Honor, but part of the story in this case is that there was a meeting where Mr. Thomas, or there was a gentleman that, according to the story, that I believe Mr. Copeland has given.
Mhm.
There was a gentleman in prison who was affiliated with If Gang.
Okay.
And through consultation with that gentleman and other people at this meeting, which Mr. Zachary was not at, Mr. Thomas and others ratified a quote unquote green light to kill YSL members. Or no, I'm sorry, let me not misspeak, to kill Kenneth Copeland.
Okay.
And so Mr. Zachary is talking about hearsay that he's heard about this green light that was put on. I don't think he specifies in this, but in other statements, it's said to be Kenneth Copeland, I believe. But he doesn't specify. He just says he put a green light on line 10 on page 68. It says, "'cause they said a powwow," and like green light, all YSL, and 30 deep. They say nut said whoop, or something like that, meaning it's a go. So he's saying they said that Nut did this and Nut did that to say it's a go to kill YSL members or 30 deep. That's Mr. Zachary's statement, but Mr. Zachary wasn't there, and he's saying they say that this is what Nut did.
Okay.
So, Your Honor, the state feels this has a huge effect on listener and also is classic co-conspirator statement in this context. And I'm trying to remember exactly where this is. I believe it's Mr. Garlington who tells, basically it's either Mr. Garlington or Mr. Copeland who gets information from this meeting. And that's why when Zachary says, like, from my notes, what he says, so Tex Gaither says, so you're saying If Gang had a powwow? And Zachary's like at the house, at their spot on MLK. So he's talking about like a specific location that came from, I believe it was Mr. Garlington, but that's just off memory, Your Honor. And then Tex Gaither says, okay, they say that YSL and 30 deep. Yes, my apologies. As the court has said, when we read, we get fast. So, in 30 deep got a green light, which basically means you kill them if you see them like they're food. And then Zachary says yes. And so that is important for a number of reasons in terms of whether If Gang members actually said yes, YSL is on the plate, so to speak. You can shoot them, kill them, attack them, whenever you see them. The fact that Zachary is stating that YSL members, to include himself, believe that was true, that is critically important for the effect it has on them.
All right. And you're saying that one of the other alleged gang members who's indicted in, or maybe has fled or not, but is indicted, actually has a basis of knowledge for what went on in this powwow, and is that what you said?
Yes, Your Honor. And my memory is either Mr. Garlington was actually, he either was there or someone at the meeting who was friendly, because Mr. Garlington was 30 deep at some point in time. And there's some friend, like people, it bleeds over. It's not like
right.
You have friends in other gangs, so to speak, or associates. And so someone calls and notifies Mr. Copeland, or maybe it's Mr. Garland who calls them. That's what my memory is of how this got to there.
Y'all have evidence of that you're intending to introduce, or do you have a good faith basis for saying he had a reason for knowing this?
Yes, Your Honor, and I will find where that is, what interview statement, but yes.
Okay, well, I mean, assuming, go ahead.
It's Mr. My understanding, it's Mr. Copeland that introduces this concept.
Okay.
I don't believe
they
Mr.
asked him about
Copeland
it on
was
the
at this
stand.
meeting either. It's entirely unclear to me, and I may just be misremembering, but I don't believe it's ever established exactly how Mr. Copeland knows. But Mr. Copeland is the other person that spoke about this, not Mr. Garlington.
But Mr. Copeland relays to...
Well, I don't know. We don't know that.
Well, he knows it somehow.
Well, I agree that he is passing along information.
He could be correct or not about it, about what happened in the powwow, but at this point,
There's no evidence that Mr. I'm not trying to be hyper technical, but if when we're talking about statements made by a co-conspirator and furtherance of a conspiracy, there's no evidence that Mr. Copeland told Mr. Zachary this.
okay, but as I understand the state's position, they're not offering this for the truth of what happened in the powwow. They're offering it to show that the alleged YSL gang believed that it was, open season on them, and that
Open
had been
season is crazy.
authorized by the IF gang. So that is permissible for that purpose. It's not hearsay at all. Okay.
Your Honor,
Yes.
and this is something that's probably going to come up later. There may be times if they're not offering these things for the truth of the matter asserted, that we have to give the jury 105 instructions regarding exactly what the purpose of the evidence is.
All right, and I would expect you all on the defense side of the room to make sure that you timely alert me to that fact before any testimony like this or cross impeachment like this comes out, because that instruction is supposed to be given prior to the jury hearing that evidence that's only offered for a limited purpose. So y'all are on notice that you need to let me know that. If you forget, then I can always notify them later, but you still have to raise that to me as well.
Yes, sir.
All right. Thank you. Okay, we can probably knock out a couple more of these before we wrap for the day. So item 12, which is bottom of 70 through most of 71.
Yes, Your Honor. So,
This would fall under your rulings about Mr. Garlington.
Okay. All right. Then that would be in if that's the only objection. All right. All right, now we're moving to page 81.
So, Your Honor, my notes, or what's said here says, Zachary says Nard says that Woody's going to fold, talking about Mr. Copeland.
Okay.
I'm like, what do you mean? I may have started this a little bit before, but I wanted to read just two sentences. And he says, I'm like, what do you mean? He's going to tell on us. I'm like, about what? About the nut situation. He's going to fold. And then he says, that's why Thug stopped messing with him, because thought he was going to fold.
I agree with the content.
Okay.
And my objection is to the speculation and explanation of what's going on in Mr. Williams' head. That's why Thug stopped messing with him. They thought he was going to fold. That is the part that I object to, which doesn't come across clearly on the transcript.
Okay. So this is who talking to who?
So, this is,
I was like, what you mean? Blah, blah, blah. Who's having this conversation?
so Mr. Zachary first is mentioning a conversation he had with Demise McMullen, who told him that he believed Mr. Copeland was going to fold.
Okay.
And then Zachary also states, I think Zachary actually then, after he says Nard thought Mr. Copeland was going to fold, he thought he was going to tell on us. I think Zachary just starts saying that's why Thug stopped messing with him, because he thought he was going to fold.
I think he says, Mr. Zachary says, I don't think he's going to fold.
Right.
He was responding to Mr. McMullen.
I didn't think he was going to fold, and then I thought,
Then he says that's why Thug stopped messing with him.
okay,
Thought he was going to fold. And that's the part I'm objecting.
okay.
And the state's position is that Zachary's has enough foundation to know what his fellow co-conspirators' viewpoints are, especially on someone snitching against them, which is of peril to individual defendants and also the gang writ large, for obvious reasons. And so the fact that this conversation is all about someone telling on other members of the gang and individuals, Zachary would have knowledge of how they would view that and why they distance themselves from Mr. Copeland. And so the state feels that he has relevant personal knowledge from interacting with defendant Williams and seeing the interactions with Mr. Copeland starting to go down.
Okay.
As in not as frequent as they used to be.
All right, so and your basis for this not being speculation is that you think that, let me just say this, before you could get this in, you need to establish the foundation for him knowing. I mean, he can know by observing that Ms. Williams and Mr. Copeland kind of stopped seeing each other so much. But if you want to impeach him on why, then you need to establish that he actually had a basis for knowing the why. Okay. Okay.
The next one is the one that the state, at least a portion, agrees with Mr. Sharp.
Okay.
So that line that says, yes, Shannon's hot-headed, the state agrees that that should come out.
How about him, all they want names for themselves? That's all they want, names for themselves.
And this is similar to the court's earlier ruling where I had asked about moving up in rank. So,
Okay, so you could use this as well to say, didn't you tell us already they want names for themselves?
Yes, Your Honor.
But only for that, and the hot-headed part doesn't come in regardless.
Yes, Your Honor.
All right.
And then,
Hang on, give me just a second to jot myself a note. 22. So I don't know what the line 25 and then the response on the next page is about. That seemed to be included in your objection.
right, so the investigator says, so Shannon, don't give a F word, and then Mr. Zachary says, oh, hell no. So that, I object to that.
Okay. Say that's just,
I will concede that, Your Honor. I'll skip past that.
Okay.
Yes. We will not be asking something about those two.
okay.
Your Honor, the next one, it says, Mr. Sharp says, irrelevant discussion of Bentley selling
Right.
drugs. Bentley being OG Bentley, who's Kelvin Treadwell.
Right.
And so I wanted to read, because I think it's a little bit cleaner, what's said in this portion. So I have Detective Gaither says the guns possibly on Bentley's spot.
Hang on, let me figure out where
Yes,
you
Your
are.
Honor.
So this is
82.
83, right? Are we back on 82?
I might have had a typo. I had page 82, line 25.
It's 80,
83, line 25.
83, line 25 is, so that was what you were reading of, Mr. Atkins. The guns possibly at Bentley's spot on Oak Drive. That's the beginning, that's before I object.
Okay. Thank you, Mr.
All
Sharp.
right.
And then Mr. Zachary says, yeah, so they're talking about Bentley's spot on Oak
Okay.
Drive with the
Mhm.
guns, but
Yeah.
then they move into selling drugs.
All right. Yeah.
Your Honor, the state's position of why this is relevant is that on page 12 of the preamble to the indictment, the state sets forth that part of the purpose of the RICO enterprise is the sale and distribution of drugs. Furthermore, there is, in both Mr. Copeland and in Mr. Zachary's statements, they speak and reference that after the murder of Donovan Thomas, Oak Drive, that's what she's referring to. And then she's like, what kind of drugs does he sell? And Zachary kind of goes into detail, dope, crack hard. And she's like, nickel and dime are rolling in. And Zachary's like, both. And so, for one, it's relevant for Zachary to have knowledge of one of, even though Treadwell was not indicted, the state's position and Detective Gaither and Detective Dennis' testimony through an earlier act where his vehicle was used to do an attempted murder of Dexter Montgomery, which is Act 36. It's very relevant, Zachary's knowledge of Kevin Treadwell dealing drugs. And the state has to prove the existence of both the criminal street gang and the RICO enterprise, which are sort of part and parcel of the same. And so the state just feels that this is very relevant, given there's also a number of drug charges on this indictment.
Right.
So it goes to count one, the RICO, is the state's position.
And Your Honor, nothing I'm trying to keep out finishes Mr. Zachary's alleged knowledge of Mr. Treadwell's house or whatever it is on Oak Drive. I mean, he's clearly saying it's Bentley's spot in Oak Drive. Before we get to the part that I want to take out.
So do you just not want it said that he sells crack?
All the drugs. This is why
That was funny how she said it.
Mr. Treadwell is not indicted on this case.
Right.
Nothing involving Mr. Treadwell selling drugs is listed as an overt act at all in count one. So we're just throwing in an associate, and there's no indication from this that Mr. Treadwell somehow kicks back money to Mr. Stillwell or Mr. Williams or anyone else. It's just Mr. Treadwell, who is associated with us through evidence that we know him. I think that evidence has come out that he's Mr. Williams' road manager at one point early in his career. But I don't know why we would get into his unrelated criminality.
All right. So if he's not an unindicted co-conspirator, if he's just an associate and there's no evidence that YSL is in any way benefiting from this guy Bentley selling drugs, seems like Mr. Sharp's got a good argument here.
So, Your Honor, on the first point, and this was the act I was referencing, but just to give a little more clarity, there's individuals at a gas station, they think someone's trying to rob them because they're coming up close, and he calls Walter Murphy, who is a defendant who's pled, and Demise McMullen to come over and shoot with a stick, and they shoot and take off half of Dexter Montgomery's head. Kevin Treadwell, he's the he.
Okay, Bentley, Kevin Treadwell is the one who makes the call, and then these alleged YSL gang members come to protect him and his drugs.
Yes, Your Honor, and that's in regards to him being like, is he an associate, a member? The Detective Dennis and Gaither would classify Kevin Treadwell as a YSL gang member. Now, in regards to the drug proceeds, I do not have any evidence that some receipt or some conversation of I'm paying my weekly dues to the YSL gang from this drugs that I sell at my trap spot. I don't have that kind of evidence. But the state, so I wanted to answer the court's question.
And in that incident, there was no evidence that these gentlemen were called to protect Mr. Treadwell's drugs. The state, I think, characterized it as just a senseless act. We were categorizing it as Mr. Treadwell believed that Mr. Montgomery and his associates were attempting to rob them outside of the gas station. But that incident, there's nothing about drugs.
All right, unless you got more than that, Mr. Atkins, I don't think that this particular part, which is 8325 through 8410, comes in.
Your Honor, I have one small request.
You may.
There's a part, and I need to get the line of it, where he says, Detective Gaither asked him, does he still drive that white Nitro? And Zachary says, nah, he let Nard F that up.
Okay.
I would like that part in because that white Nitro.
All right, that is not a part that is objected to, that's being excluded.
That's line 12 on page 84.
Thank you.
All right, sure.
I wonder where Doug Weinstein at, cause his fill-in don't be saying nothing. Less than Doug be saying.
All right. 85, line 13 through 86, 11.
So, context here, Your Honor. Mr. Treadwell is actually, at the time, I don't think they're still together, was actually in a long-term relationship and has a child with Donovan Thomas's sister.
Okay.
And so this is all a discussion about, there's a lot of speculation about what Donovan Thomas' sister knows and how she feels about this and how she feels about Mr. Treadwell, which I don't think is relevant.
Your Honor, the main portion of this, so to speak, that the state wanted in is not as much about what his wife knows. It's more so this line where he says she doesn't know that he, talking about Kevin Treadwell, hid those guns and had something to do with it, talking about the murder of her brother. And so,
where is that?
I will find the line.
That's 86 line 1.
The state don't never know what nothing is.
Unintelligible. I have, she don't know he had something to do with it.
Okay.
And he's already laid out in the statements that I've objected to, but Your Honor has overruled my objection about what, this is all based, he had something to do with it, is all based, from my understanding, is pretty clear. Mr. Zachary is saying that's based on what Mr. Garlington said to him, and that's been repeated several times throughout these statements already about Mr. Bentley getting, Mr. Treadwell allegedly getting rid of the guns. So I don't know why we would need to get into this conversation about what she knows and just for that information, because it's already been provided.
Your Honor, one other small piece is, I don't remember when this question was asked or who was asked of, but Donovan Thomas Sr. testified. And there was some questions about, the state asked questions about relationship, family members, to give context for the jury. And so there was some questions, I believe, on cross-examination of Mr. Thomas, kind of highlighting that Kevin Treadwell's wife is related to Donovan Thomas. Because obviously that would cut, this is my idea of why defense would highlight that would cut against their family. Why would he be involved with the murder of his wife's brother? And so, but the state feels that discussing that, because of some of that testimony, this isn't going to be a huge part of our direct questioning of Mr. Zachary, but that is another reason why it is more relevant than it may otherwise be, that she didn't know. Zachary's saying she didn't know. Because obviously it would be very odd if she did.
Okay, so then most of 84 and 85 is admittedly not anything y'all would need?
Yes, Your Honor.
Okay, so then if part of 85 and top of 86 becomes relevant, I mean, it's still like Zachary saying, I don't think she knew, right? I mean.
Yes, Your Honor, and I don't think we're going to be asking specific questions to try to, about this. It was the topic about, her just, well, it may never come up in our direct example.
How about if you think it's going to, you raise it with me and
Yes,
we'll
Your Honor.
hash it out then?
Yes, Your Honor.
All right. 92, first couple of lines.
So, Your Honor, I have, and Mr. Chart, you tell me if you have something different. I have, Detective Dennis says, what he thought, get you down there, what was Thug like? Zachary says he's normal. Detective Dennis says he doesn't give an F, and then Zachary says, he's like, why the hell did they kill Nut? That's when I guess they told him. Nut said it's a go, and then he says, Woody, talk about Mr. Copeland is holding back stuff. He's kind of alluding to Mr. Copeland has friends. He knows a lot of people, so sometimes they're saying Mr. Copeland doesn't state everything with him.
I'm going to withdraw.
Okay. And man, y'all weren't kidding about the transcription being less than 100% accurate. Okay. It is not this court reporter or my prior court reporter. I do not have any idea who this state used, but maybe
Spares them on the record, Your Honor.
like entirely off the record. Maybe next time y'all have a bunch of stuff transcribed, you give them like a list of key terms and names of people, and that would help them out a lot. Okay.
Well,
anyway, totally irrelevant, but
damn.
okay. So
In light of my review of the transcripts, I'm going to withdraw my objection on number 18.
Also, okay.
Because I believe that, not saying it's the truth, but I believe Mr. Zachary was there.
Okay. All right. Then we are at number 19, 102, 15 through 22.
And Your Honor, this is one of those ones that the state agrees. This is just a line with Detective Dennis speaking about basically the streets depicting King Copeland.
So y'all concede that one.
Yes, Your Honor.
Agree, redacted by agreement. Okay. 104, middle of 104 to middle of 105.
This is another one that we will concede. Its relevance is very limited,
Okay.
so
Thank you.
I will agree on this one.
Okay. All right, that takes us to page 108.
Your Honor, this came up in the 2017 interview. This is in relation to who shot Mr. Bennett, wife, and Lucci's mother's house. I wanted to point out, because this did not come in, this part, in the 2017 interview to my knowledge, but in the part of this interview, which I have begins around on the evidence reviewer time hacks 30850, Detective Dennis says, let's get to this, who shot up Lucci's mother's house?
Okay.
And there's a little bit of back and forth, and then Zachary says, I'm telling you all if you work with me. And he says, Woody, Shannon, and Little Pokey. And then they ask him,
Little Pokey is crazy.
Who these people are, and he's like, Little Pokey is Thug's nephew. And this is where the part I think is important for his knowledge of this. Gaither says, the gun that you had that you got caught with, she's telling him about the ballistics from the gun that Zachary's arrested with, comes back to one of, because there was two, shootings of this house.
Uh-huh.
And Zachary's like, well, that was Moontongue's gun, who is Antonio Sledge. And so he's talking about how did Woody get that gun that day? Because Zachary's like, the people who did it was Woody, Shannon, and Little Pokey. And so this is why I think it's important. Zachary says, we were at Big Boo's grandmother's house, and Mr. Copeland's like, hey, let's ride. They leave, and they come back in a white Charger, which I believe is Mr. Copeland's brother's car. And then Big Boo, who was kind of a lot of people looked up to him. He had a lot of money in that neighborhood.
Okay.
And so people would call him to settle disagreements, basically. And so he gets a call from someone in Lucci's like an associate or friend who's like, hey, whoever just did that, I got $10,000 on their head because you just shot at his mother's house.
Okay.
And so
Damn.
what Zachary states is while he's at Big Boo's house, Woody and them come back while this phone call happens. And he says, Woody comes in and Woody's like, what happened? He acted like somebody just shot up Lucci's mother's house. And then Big Boo's like, don't tell me you all did that, because they came back and didn't say anything. And he says Woody got scared because, and he says, Moncho, who's the person who calls, says, I have $10,000 of whoever did it. So to me, this is my rendition of this. Zachary kind of is like, I know that on some level they did it because they suspiciously leave, come back, and then he gets this call of who did it, and then Kenneth Copeland starts acting paranoid when they're saying, I have $10,000 on the head of someone who did that, coupled with, and I don't have direct evidence of, on this date, Mr. Copeland told Zachary, I did it, or Mr. Stillwell, or anyone told Mr. Zachary that, but I couple him being present around him shortly after this happened, coupled with his just daily interaction with him. He actually has more, his knowledge of Lucci's mother's house, he's not present, but is less speculative than it may first seem from interacting with co-conspirators.
Okay.
That's my argument on this. But given the court's earlier rulings, I wanted just to highlight it came out more speculative when we addressed this incident.
Okay, and so here, Zachary is saying that he is at whoever, Big Boo's grandmother's house with Woody and whomever, and they leave, and then word comes in that Lucci's mama's house gets shot up, and then Woody and them come back while a phone call is being taken about whoever did this, there's a price on their head. And then Woody acts really suspicious, is what you're saying.
That is
my phone by that.
much more concise rendition of what I just said, Your Honor. Yes. I have that large block starting at that certain time, and so yes, that is my understanding of what Zachary says, that he's at a house with them, they leave, they come back, they realize it happened, and Mr. Copeland acts suspicious, which is decent clues of possible involvement. And I believe, I have no evidence of this, I just believe that coupled with they tend to talk amongst each other about what happened.
So on 110, unless it's transcribed wrong, I guess it's Detective Gaither says, so they actually came back and said they did it, or y'all just assumed it? And Zachary says, no, they said they did it.
That
He says he finally said it. Yes. Was this unintelligible? Says Booty. Like I told you, Booty got scared when they said they got $10,000.
Okay, and then on the next page it says, and then what's the unintelligible part there? Okay, well that to me is him actually saying we
Yeah,
did
it's
it.
real bad. That's why I'm staying my ass home.
Okay, why?
Your Honor.
Stay my ass
Well,
on
Mr.
YouTube.
Copeland's not saying I did it, he's saying we did it.
These roads already bad on a normal day.
What I'm saying is, I don't know what I've never heard Mr. Copeland's in-court testimony about this and what that would be, but it's certainly not an admission by a party opponent that could be used
What
against
did you do, Lamar?
Mr. Stillwell, because there's
Hell
nothing
yeah,
in here
thrown
about
out
Mr. Stillwell
long time
saying he
ago.
did anything, and I don't know how. I mean, it's hearsay, and I don't know what exception this would fall under. I have a theory of what the state may argue, but it's not furthering anything. Except Mr. Copeland is apparently paranoid or whatever, and maybe he has some self-interest he's dealing with, but I'm not sure how it furthers anything. And so I don't want my client to be wrongfully linked to uncharged, well, I should say not substantively, and let me just say this too, no one's been charged with this act.
Okay.
It's listed as overt act, but no one's been substantively charged with the actual crime.
Alright, so who all is, I mean, I get that Zachary is at the house, at the grandmother's house, and Woody is at the grandmother's house and then leaves and then comes back. Who else is at the grandmother's house, leaves with Woody and comes back, if anyone?
So, Your Honor, I believe, so the closest I get is when they ask him who did it, he says Woody, Shannon, and Little Pokey. And he says collectively, like earlier he says, Woody's like, hey, let's ride, like collectively.
Okay.
And then he's like, they got back, or, so my understanding is, he doesn't definitively say this, but I believe either Shannon and Little Pokey were at the house and left. I'm just assuming from the way that he's speaking about it. And also, this is partly, it's the end of the day, but the court is correct that shortly thereafter, Mr. Copeland himself does state, it says, you know,
well, and I mean,
I did it.
If Shannon, and I guess Little Pokey is not anybody that we need to concern ourselves with right now.
He is Defendant Williams' nephew and someone that...
Okay, but he's not somebody on trial right
He's
now
not on
or
trial.
indicted?
He's not indicted.
Okay. All right, so if...
Wonder how they came up with the people that did get indicted.
He says,
Wow.
let's ride. And he, right after they've said, after Zachary said, here's the 3 people that I believe did it, and here's my reason for believing it. But in order, I think it potentially could be a statement if Mr. Stillwell shows back up with Mr. Copeland, and then Mr. Copeland's like, yeah, man, we did it. And Mr. Stillwell does not say, what are you talking about? I didn't do it. You might have done it, but don't count me in on that. Then that might be an admission because he's adopted it by silence. But not if he's not there when it gets said. So, you know, if you can establish that when Woody says, yeah, man, we did it, that Shannon's standing right there with him, knowing there's $10,000, you know, on his head, then yes. But otherwise, no.
Understood, Your Honor.
All right.
Your Honor, address one small part on that. In regards to taking aside Defendant Stillwell, in regards to what Copeland referred to Zachary, that's appropriate, depending on how testimony of Mr. Copeland comes out, coupled with foundation for Mr. Zachary.
Yes.
Okay. Thank you, Your Honor.
And that might be one of those times when we might need a limiter if that comes out.
If I understand the state's question, they're saying, can we get into the fact that Kenneth Copeland admitted involvement?
Right, yes.
Without bringing Shannon.
Right, that was the second question, yes.
If we can't get to the adoptive admission.
Yes.
I don't have a problem with that.
All right. All right. We just have a lot to get done, but these are Mr. Zachary's only 2 statements that we need to get through, right? Yes. And we're about halfway through, I think. Assuming Mr. Copeland, to try to figure out scheduling, assuming that y'all need to move to your next witness, right? Yes, right, yes, so. And I know Zachary's one of the next ones up. He may not be the very next one up, but is would be hitting next week, because after next week, the jury already had a week off, so we can do this delightful stuff that week, the week of the 19th, with regard to future witnesses. But are there other witnesses that, assuming Mr. Copeland does not testify, that we would reach next week whose evidence we have to hash out?
Yes. Mr. Sledge is the other person that I,
Okay.
Oh, that's a co-defendant.
smaller.
Okay, can I go ahead and get that interview? And you have listed also a jail call,
Definitely want to
right?
see him on the
And
stand.
then social media. And
The water comes up to your forehead.
Can you
I don't think
get
it's that bad. Well, in
the
certain
more
spots it's
detailed
like that.
information, this was supposed to be here today about at least these witnesses to the defense, not social media, but what? If, I mean, they may have it, but if they don't have it, we need the detail. Yeah.
So can we provide that to them for, like, in the morning, or, like?
Do you have any of it ready right now? Because I know that your person working on it had been worried that he or she could not finish it all as to the first 30 witnesses, but surely he or she has accomplished the big chunk of it by now, right?
So those were the exhibits that she was working on. So we had the court instructed us about the exhibits, and so that is what that person was working on, and I was hashing out the full of the 30 witness exhibits that we were introducing.
All right. So how far along?
She has me chilling though. I ain't gonna lie.
Have you done like page 1 of it? I mean, I assume you're going by, in the order that you prefer.
So can I, will the court just, so may I send to the court or to the defendants to the court by 9 o'clock tonight? So everything that I have compiled.
Can you just send right now or in the next 45 minutes what you have so far? Because I'm sure that, well, what I suspect is that everybody would probably like to get some sleep, but that's not the reality of being in a trial. And so the sooner you can get them the stuff, the better. So let's not wait till 9. Let's, in the next hour, get what you've got right now over to them and me. And hopefully it'll be a big chunk of it. Okay, so, and then you need to send me, I assume the defense has a copy of Mr. Sledge's interview.
Yes.
Have y'all done this same
Damn,
exercise for Mr. Sledge to figure out what portions of it you need to object to?
What's Sledge's nickname? I forgot. Is that Moonton?
No, I will say Mr. Sledge's interview is shorter,
Okay.
and it's really confined to the incident that he's charged with,
Okay.
is the shooting up of houses he was charged with back in 2015 that him and Mr. Zachary pled to.
Okay.
It was taken after being arrested for that.
Okay. So I'm thinking that potentially the defense might have objections to social media, the defendant interview, or jail call or calls. But I don't know that. Do y'all know what you're going to give them, the specific social media? All right.
Yes, and Judge, just for a point of clarification, we were trying to include on it the exhibit numbers. That's what
Yeah.
I was.
All right. Well, that's wonderful. But if the exhibit numbers aren't perfect, fine, we can fix those. Is that what your concern was? Okay. No, my concern is more that the defense get the evidence you're planning to use, because they need to be able to contemplate it and figure out how they're going to deal with it. All right, so
Really? I'm gonna watch that after. Cause I think they about
which
to
means that
end this
if
in a
we're
minute.
doing the trial next week and it isn't a couple of days of Copeland and then a couple of days of Zachary and people who, you know, there aren't going to be a lot of objections to. I mean, we need to have hashed out this with regard to all of next week's witnesses.
Yes.
And how are we going to do that? Who all do you think there's going to be objection about other than Sledge and Zachary? And y'all, I'm looking at this giant list of witnesses from the state and looking at the first ones, and surely y'all looked at most of this. Do y'all think that there's another witness coming up soon that we're going to have a lot of this kind of detail to hash out for?
No.
I mean, you don't think so? Okay, great. Does the defense think so?
Let me see. What video did he put out?
So
I still gotta do my video on that. I don't know if I'm gonna watch that one. I don't know yet.
the state has
Well,
seemed
watch
to
it on live
interviewing-
anyway.
I mean, trying to introduce prior statements through the witnesses
You know
that
what?
are
I
on
can't just
stand.
react to that one.
Mr. Detective Thorpe and Michael Sprinkle, ADA Sprinkle, both conducted multiple interviews. I don't know to the extent that they're going to seek to introduce any prior statements through them, but that's the only thing that I can see. Mr. Sledge has a prior interview,
Right.
but my recollection is it's very confined to one incident, and he doesn't say. I'm going to review it, of course, but he doesn't say anything about anyone other than himself and Mr. Zachary, mostly.
Okay.
My recollection.
Okay. Thank you. Anybody else see something that's going to be a whole lot of what should have been motions in limine?
Your Honor,
Yes.
trying our best to give you an estimate of what we think might be at issue. I'm looking, for example, number 8, Michael Sprinkle.
Yeah.
So yes, we're aware that he conducted multiple interviews, but what we don't know at this
Who the
point
hell
is
is
what
Michael
interviews
Sprinkle?
it is that they intend to use. So we don't really know how to
All right.
address that. We also don't know what social media
All right.
items.
I think we're going to have a whole lot more of that in an hour. Tell me this, Miss Love, assuming Mr. Copeland does not testify, what witness do you think we are going to be at by next Friday? Keeping in mind that y'all will be here at 8:45, the jury will be ready to go at 9, and we will work till at least 5:30 most days, with a break for lunch and a couple of bathroom breaks, and that's about it.
Thank you. We ain't got time for all them. What he used to call it, convenience break, comfort breaks, or whatever. And them breaks used to be 30 minutes to an hour apiece.
No further than, and when I say Agent Bernie, it's for these records that we have, not for the
Okay,
ones that.
right, we talked about earlier, yeah.
But we will get no further than Agent Bernie.
Okay, all right, and so, will what you send in an hour cover at least through Agent Bernie with detail about what the evidence is going to be? Okay. All right. Okay. Well, then we'll take it from there tomorrow. Let's be here at 8:45 tomorrow. And y'all think about the things that I asked you to think about and have some kind of proposal for me.
Is completing are we completely abandoning for now the Zachary statements, or are we taking that up tomorrow?
No, I want to get through Zachary tomorrow and then move on to Sledge and then whatever else. But no, we're just abandoning that for now. It's time to go home.
Understood.
All right. Do we need another chart? Mr. Atkins, could you send over an electronic copy of this transcript of the interview we're going through right now?
Yes, Your Honor, I will.
Okay, thank you. All right, we're adjourned. Excellent, thank you. Give the original.
And that would be great. Okay, sounds good. All right, bye. All right, y'all. The YSL case is over for today. I'm about to watch one of the Music 101's videos real quick. Is it currently? Hold on, y'all. Yeah. Before I end this live, I'm gonna go ahead and watch it. So
subscribe to the YouTube channel. Hit that.
Okay, hold up. Hold on. Wait a minute. I still got to do my video to this, but I just want to see what he says. I got my own theory. But let's see what he says. Shout out to Music 101. If y'all have not subscribed to his channel, make sure you do so.
Sean Gaithright messaged a female and asked her to contact a male who was with Julio Foolio, attempting to solicit updates on the victim's location from 1:32 a.m. to 2:25 a.m. on June 23rd, and stopped messaging the person after the suspect Cruz had a line of sight on the victim in front of teasers. First question I have, did he receive any information from the male or the female that was with Foolio? And if so, why the police haven't identified the other parties or put a warrant out for their arrest? Foolio mom confirmed there might be more arrests to come. Report said Isaiah Chan's phone was not as active since he primarily used Alicia Andrews' phone during the surveillance and tracking of the victim's vehicle. However, it too also tracked from Jacksonville to Tampa. Chan's phones tracked to 15th and Hillsborough on June 23rd at the same time the silver Cruz hit the license plate reader. Chan's phone also tracked to the homicide scene at the same time that Cruz was seen on camera there. Chan's phone was in the vicinity of the Airbnb at the same time he is seen on the rain camera.
Okay, shout out to Music 101. I think he breaking down the paperwork. Have you read the police report? It's not a police report, actually. It's a motion to deny bond. But yes, I was on live for the third time the other day. And I read most of it during that live. I've been clipping down the paperwork into different videos. I I think I dropped 2. No, I think I did 3 so far. So if y'all have not, make sure you go check it out. I did 1 the other night, and then I did 2 today. Hold on. Yeah, so I did the video. So like I said, the live itself, which live was it? It was this live. So I read the paperwork out loud. But now, because I'm thinking a lot of people are getting kind of confused, because like the blogs and even on YouTube channels, they're just picking like different words. And one thing, y'all know, I created a lot of my foundation on my platform with the Queen of Paperwork, and a lot of people don't read paperwork for sure. And I feel like because the blogs are highlighting certain key things, that people are still running off with these narratives. So I've been like breaking it down into parts. So like I said, I did this one about Rashad Murphy being caught in one of the cars. I did this one in regards to the details of the police investigation, because you know this whole theory is that it was a backdoor situation. And kind of like where it left off when we just watched a music video, it does say that Sean attempted to solicit information. And in my view, when it says attempted, that's just like attempted murder, meaning you didn't kill the person, but you tried to, right? Or attempted robbery. You tried, right, to rob somebody. So attempted to solicit information, meaning you tried to get information. And I feel like if they got information from the female in regards to any details that the male that was at or with Julio Foolio, they would have added that to the motion. But how is, again, I break it down in the video, but again, in my opinion, all the information that they had as far as the locations and all that were posted to Julio Foolio's social media. And what people don't realize is this, and matter of fact, I can just talk about it real quick. This is actually my next video to this. Hold on. Let me just show y'all. I like to show y'all my thought processes and how I'm getting there. So if you just go, I meant bring the whole thing over. Hold on. So if you just go to Twitter, to Julio Foolio's account, right? And if you go down to June 14th, right? So he posted that he was going to be at Teasers on June 14th, right? He posted that on not only his Twitter, but also on his social media. So what people haven't, I guess, paid attention to, maybe somebody has paid attention to, in a motion that was filed for the defendants, right? It says that basically, what is her name? Alicia Andrews started soliciting someone to book an Airbnb in their name for her on June 21st. Okay, so y'all see here, Tampa, Florida, my Airbnb pool party on June 21st. So they were attempting to set up them going to Tampa for whatever reason. Okay, now of course everybody is innocent until proven guilty, right? But they have, according to the document, proof via her social media she was attempting to get someone to put an Airbnb in their name on June 21st. Now ultimately the Airbnb was booked by Rashad Murphy, which is one of the defendants in the case, right? So they have evidence of that. They have evidence of the reservation confirmation. They have evidence of the payment used to book the Airbnb, which led back to Isaiah Chance, which is one of the co-defendants also on this case. So again, based on how they outlined the details, to me, it wasn't no backdoor situation because, again, if they would have got information from the female or the male, it would not have said attempted to solicit. It would have said Sean Gayfright solicited info from a female. Okay, like it would have said that. It would not have said attempted, right? If they would have gave them something of value. Now, I'm doing a video because, again, in that interview, and we reacted to that yesterday on live, of Julio mom, she did have a point, right? It has to be more arrests. We don't know these people, right? Somebody had to send you. Now, if y'all didn't see on one of my other videos the other night, it was said in the paperwork that bullet shell casings was found with Sean Gayfright from the October 7th, 2023 Foolio shooting when he got shot in the foot. So I'm going to be honest. It does seem, again, he was coming back. He tried in October, didn't work out. He came back in June to do it again. So he was on a mission to do it for whatever reason. Now, maybe he got a vendetta with Julio, maybe, according to the police, they haven't tied him to no gang affiliation, but maybe. Or it could be that he could be a hitman. He could be. I mean, it ain't far-fetched to think so, especially with his background. But, yeah, so that's basically what's going on as far as my content. I'm just trying to break it down as clear as possible for a lot of people. So one thing I have cleared up is, I don't see no way around saying that it was a backdoor situation. They got the information clearly from public record. They started planning this hit, quote unquote, on the 21st. They left on the 22nd. Before they even went to follow Foolio to find him, they checked into the Airbnb. They actually checked into the Airbnb before they even went out to find Foolio, right? They also, right, not only did they check into the Airbnb, they went to McDonald's. So they went to eat before they went to find Foolio. So to me, they were just laying in wait, because if you look at the flyer, can you look at it on this one? It tells you it doesn't start at 8 p.m. 8 p.m. to 3 a.m. So it tells you the time. I didn't even realize Kenny K was on there. But yeah, so like they knew roundabout where they could find him at. So from public record, here we are, over a month or so since, and you can still go find the postings. So again, so far I think it's accurate. The first half, I think it's plausible to say yes, they got the details from public record. Although Sean may have tried to get information from somebody, but guess what? They don't have. I would have it's just me. That's just my opinion. They definitely would have put in if they would have got some information from the female that he tried to get the information from and all that. Now, who are the other arrests? It's going to depend. Now, I'm going to tell you this because I got to do a video on it. But yes, it does say that the female does confirm it's her in the videos they have, because the paperwork shows they got a lot of videos. So the female did confirm that it's her in the videos and confirm that her boyfriend Isaiah Chance is in the videos, right? So she did say that. Now, my personal opinion is that if this is a hit or murder for hire, however you want to put it, I doubt she would have those details unless somebody was pillow talking, okay? Unless somebody was pillow talking. I don't think she was in a know of that. So, like how much can she really give them to get to that point? So the question is going to be, does Isaiah Chance start talking? Does Sean Gayfright start talking? Now, one thing about Sean Gayfright, he tried to escape from the interview room, okay? When they got him this last time, he tried to escape. Isaiah Chance threatened to run. So that they put that on his motion too, to not give him bond because he threatened to run. He said if he gets out, he's out of here, okay? Rashard Murphy is still in Jacksonville. He has not been moved down to Tampa, so I don't know what his paperwork would say. Now, what everybody should know or don't know, right? What to do, James, is that although for the most part, the documents are the same, each defendant has a motion to deny bond, each one. Most of the information is the same on each one, but it's going to be slightly different for each. Because, again, you go look at Alicia Andrews' motion, it's not going to have that Sean Gayfright tried to escape out the interrogation room, out the window. If you look at Sean Gayfright, it's not going to have that Isaiah Chance threatened to flee if they let him out. So that's one thing you got to keep in mind too. Although it's the same motion, for the most part, same information is different. All right. So that's pretty much it. Y'all just watch the videos. I'm going to be working on some more videos tonight to drop. Since tomorrow, like I said, I don't know if we just going to watch trial all day tomorrow. If we're going to do some other stuff, I don't know yet. But nevertheless, I'll be live as always, 8:45 a.m. in the morning, Eastern time, of course. So y'all tap in with me. I appreciate everybody. I'm on the road to 20K, okay? I am on the road to 20K. Currently, I need about 100 and what? 23. I need 123 more subscribers. So y'all make sure y'all share the videos, share the lives, tell all your family to subscribe to Mickey Truth. Give me the 20K. Yeah, that's the next milestone. All right. So I appreciate y'all for rocking out. Y'all know this is the second live of the day. If I'm not mistaken, I think we met my goal for the first live. Let me see. We gotta do better with the likes though. You know, by liking the content, it shows YouTube that you rocking out with Mickey Truth, okay? So they can push it out so other people can pull up. So make sure you like it more. Make sure you comment. Run the comments up. Like, talk your junk. Like I said, I don't even be tripping. As long as you don't be like passing false info or saying like some weird shit, I be letting y'all pop off. I don't even be minding, for real. Alright, so my goal for the first live was 35K. We actually got down to 38K, so I appreciate y'all. We made my goal. This live, I didn't really have a goal for this live, but we hit 30K on this live. So, hey, 60K for the day. Job well done, okay? So, shout out to the Truth Team. We just got to do better with the likes, man. Y'all know, trying to grow the platform, grow the channel. I appreciate everybody for rocking out. With that being said, y'all know I get long-winded, but I got a lot of videos to do. So, y'all go catch up on all the content y'all missed out on, and I'll see y'all in the morning at 8:45 a.m. Eastern Time.